for admission. Item number 1.
Yes.
May I please, Your Worship? The grievance of the petitioner is regarding fixation of his pay as per the revision of pay rules 2010. Under the ROP 2010, if I may take your Lordship to page 149.
Yes.
Page 149, Your Worship. This is the ROP 2010.
Yes.
Rule 1, subclause 2. They shall be deemed to have come into force on 1st day of January 2006. The pay under these rules shall be fixed notionally with effect from 1/1/2006. However, actual monetary benefits shall be paid with effect from 1/1/2009.
Correct.
And if I may take Lordship to page 163. Page 163, Rule 13. Lordship, there are two rules, and Rule 13 relates to fixation of pay on promotion on or after 1/1/2006.
163,
Rule 13.
Rule 13, yes.
This rule is with regard to fixation of pay on promotion on or after 1/1/2006. Now, if I may take your Lordship to page 167. This is Rule 15, Table 2. Page 1.
No, what does 163 say? In the case of promotion, this Rule 13, in the case of promotion from one grade to another in the revised pay structure.
So this is the rule with regard to fixation of pay on promotion.
Okay, then
This is Rule 15, Table 2, is with regard to fixation of pay for direct recruits appointed.
page 167.
167.
Table 2.
Rule 15, Table 2. This is with regard to fixation of pay for direct recruits on or after 1/1/2006. And if your Lordship will see, at the,
Yes.
at the bottom of the page, pay band 2, 9,300-34,800. And we are concerned with grade pay 4,400. Pay in the pay band is 10,520. Total pay is 14,920. So, Your Worship, because of the implementation of these rules, when a person is promoted, his pay is fixed under the Rule 13. And in the case of the petitioner, when he was promoted to
No, just a minute. 163 talks about Rule 13.
Yes.
And then Table 2 talks about rule, which rule?
Rule 15, Your Worship.
Where does it say Rule 15?
Top left-hand corner.
Top left hand.
15.
Acha. Okay. It is slightly. Okay.
So, Your Worship,
So Rule 13 is on promotion for
Yes.
promotees.
yes,
So Rule 13 is for promotees.
yes. Table
Okay.
2 under Rule
And
15.
and Table 2 Rule 15 is for direct recruit.
Yes.
Nah.
So, Your Worship, now, for example,
Now what is so this is the pay for direct recruit.
yes,
Now what is the pay for promotees?
promotees are under Rule 13. Pay fixation.
How
is-
much?
Your Worship,
We don't know what is the
So
amount.
that is why I'm coming to that, Your Worship. When the pay of the petitioner was fixed on his promotion to sub-inspector in the year 2008, they were going to fix it as per Rule 13. But the pay of the promotee for the same post of sub-inspector was lesser than the pay of the direct recruit under Rule 15, Table 2. So there was a pay anomaly. In the case of direct recruits for the same post, there was a higher pay, and for the same post, promotee got a lower pay. So there was a pay anomaly. So in 2008, when the petitioner was promoted, his pay was fixed by the respondents as per Table 2 of Rule 15. That is for direct recruits, although he was promoted to the post of SI.
In 2008.
Yes,
But he was promoted when?
2008 to the post of SI.
To the promoted, pay fixed
As
As
per
per
Table 2, Rule 15, which is for direct recruits.
as per Table 2 Rule 15. Okay.
So then Your Worship,
Now, just tell us one
Yes.
thing beforehand. Was the pay scale of the promotee higher or was the pay scale of the direct recruit higher?
no, Your Worship, similar pay scale.
Similar.
Yes,
So it's the same.
yes. That Your Lordship will see if I take Your
No,
Lordship.
no. So you mean to say, as per whether they get the pay as per Rule 13 or Rule 15,
Yes, it should
Table
be similar.
2. I'm not talking about it
Yes.
should be.
Yes.
I'm saying is it similar?
It was not similar. That is why the pay
So
normally is come.
that is why please make it simple for us.
Yes,
for us.
sir.
You thought you understand everything, but for us we don't understand. So you have got to make it simple for us.
Yes.
So as per Rule 15 Table 2, for direct recruits, the grade pay is 4,400. The pay band is 10,520,
Yes.
and total is so and so.
Yes.
Now, as per Rule 13, how much would it be?
It was lesser than this.
How much?
That I don't know the correct figure, exact figure, but because it was lesser than this, when the petitioner was promoted to SI, his pay was fixed by the respondents according to this Table 2, Rule 15.
Okay, as per table.
As per this. And Your Worship, just to clarify that point, page 135, the affidavit filed by the state,
One?
page 135,
Yes.
I'll just read para 18, Your Worship. That with regard to the page 135, Your Worship. Para 18.
Yes.
That with regard to the statement made in para number 26 of writ petition, I say that the present case should not be
Wait,
confused.
just a minute. 135.
135, Your Worship.
Yes.
If I may read para 18. That with regard to the statement made in para 26 of the writ, I say that the present case should not be confused as different pay scales for the same post. It is the case of pay fixation method. The pay scale of sub-inspector of police is pay band 2, rate pay 4,400, 9,000 to 300 to 34,800 for both direct recruits and promotees, which can be clearly seen from serial number 475 and 478.
So it's the same.
It is the same. There is no separate pay scale, but the pay fixation has caused the anomaly. When they fix the pay as per Rule 13 for promotees, it comes lower than the pay of direct.
But then you
recruits.
just said just now that your pay was not fixed as per Rule 13, just fixed as per
Yes,
Rule 15.
that
so
was
what
in
is wrong?
2008.
Huh?
Now coming subsequently, when I was promoted to inspector in 2022, that is after more than 12 years, they refixed my pay as per Rule 13.
No. So in 2008, you were promoted as SI.
SI.
And in 2022, you are promoted as inspector.
Inspector.
Now, as inspector, so now inspector's pay scale is
Yes,
different
it's
according
different.
to you.
Yes.
As per Rule 13
Yes.
and what is the stand of the government?
When I was promoted to inspector and my pay was fixed, they said that my pay at the time of promotion as SI was wrongly fixed. So they refixed my pay, and due to which my basic pay became much lower. Then my pay.
Have you challenged the rules?
No. Your Worship,
You challenge the rules, no?
No,
You see, now you see, now what do you want us to do?
Your
You
Worship-
want us to pass an order against the rules?
no, in a similar matter,
Huh.
which went right up to the Supreme
Yes,
Court,
yes.
trained graduate teachers,
Huh.
same under the ROP 2008 central pay rules, same provisions were there. For promotees, Rule 13, for direct recruits, another table was there. And due to the fixation of pay, in that case also, the promotee trained graduate
But
teachers.
there must have been a challenge to the rules there.
There was no challenge to the rules. I have annexed the judgments here.
But you see, there
And the Delhi High Court held that they went to CAT. The teachers won the case. Government of New Delhi, NCT, they went in appeal to they filed a writ petition to the Delhi High Court. High Court upheld the decision of the CAT, saying that there cannot be two different pays.
We are in agreement with that. That's not
And
an
in
issue.
that case also, the matter went to Supreme Court also. Matter was dismissed. And in that case also, the rules were not challenged. But the Delhi High Court held that when the pay of the promotee is fixed, it should be stepped up as the pay of the direct recruit. If I may take a lordship to the decision of the
that is
Delhi
all
High
right.
Court.
We understand that. We understand all that. It's not that we don't understand what you're saying.
So that even
we
in my humble
just a
submission.
minute. Let us also say.
Yes, yes.
We've been hearing you for the last 15 minutes. We just want half a minute of your time.
Yeah, it's my
Please
duty to
listen.
convince you. That is
No, but it's our also duty not only to listen,
Yes.
but to also voice our doubts. If you want a one-way traffic, we can do that. We'll keep quiet and pass order as we deem fit. Then that's not a problem. It's two-way traffic. You see, the thing is that when the rules are there, the rules have been made under what provision?
309.
309. Now, if the rules are not under challenge, can we pass an order which is against the rules? And you see, unless you challenge the rules, can we even read down the rules? Because Supreme Court has said that unless you challenge the rules, you cannot even read down the rules.
If I just may take a lordship to the
Yes.
Delhi High Court judgment.
Okay. No answer.
Page 119. I am relying heavily on this judgment. That's why, Your Worship, if I may be allowed to read it.
Yes.
Page 119. The impugned order dated, this is a writ petition filed by the government of New Delhi against the judgment passed by CAT. CAT had allowed the application filed by the trained graduate teachers. So, the impugned order dated 4/4/2016 passed by the principal bench of CAT allows the OA number 3217/2009 filed by promotee trained graduate teachers who are the respondents before us. Respondents were promoted as trained graduate teachers before or after 1/1/2006. The question raised and answered in favor of the respondents by the tribunal relates to fixation of their pay under CCS Revised Pay Rules 2008 and whether there can be two pay scales for the same post of trained graduate teachers, one for promotees and the other for direct recruits. The petitioners herein had applied Rule 7, which postulates multiplying the pre-revised basic pay with 1.86 factor, and Rule 13, which provides for granting one increment equal to 3% of the pay band and pay being rounded off to the next multiplier of 10. As far as new direct appointees are concerned, they are given benefit of entry-level pay indicated in Section 2 of Part A of the first schedule of the rules. The entry-level pay of direct appointee trained graduates teachers was higher than the pay scale of respondents fixed under Rule 7 read with Rule 13 of the rules. This anomaly was noticed by the petitioners themselves, who had issued clarification dated 13/3/2009, which reads as under. I am directed to say that the matter relating to stepping up of pay of seniors with directly recruited juniors recruited on or Central Pay Commission was taken up with Department of Expenditure Ministry of Finance. It has been decided that stepping up of pay of seniors will be permitted with reference to, this Yorship is difficult to understand, of their directly recruited juniors who are recruited on or after 1/1/2006 and whose basic pay is more than that of the seniors subject to the following conditions. A. Stepping up the basic pay of seniors under the above provisions can be claimed only in case of those cadres which have an element of direct recruitment and cases where a directly recruited junior actually drawing more basic pay than the seniors. In such cases, the basic pay of the seniors will be stepped up with reference to the basic pay of the juniors. B. Using the above provision, government servants cannot claim stepping up their revised basic pay with reference to entry pay, the revised pay structure for direct recruits appointed on or after 1/1/2006 as laid down in Section 2 of Part A of First Schedule to the CCS RP Rules 2008 if their cadre does not have any element of direct recruitment or in cases where no junior is drawing basic pay higher than them. Stepping up of pay of the seniors in accordance with the above provisions shall not be applicable in cases where direct recruits have been granted advance increments at the time of recruitment. This issues with the approval of Ministry of Finance, Department of Expenditure, Implementation Cell, Government of India. The above clarification notices that pay scales at the same post in some cadres, in the case of promotees, were lower than the pay scales applicable to direct recruits. To correct this anomaly, the clarification states that stepping up of basic pay of seniors would be permissible in the case of those cadres where appointment by way of direct recruits is permissible and when direct recruited junior actually draws basic pay more than the seniors. This clarification has not been accepted by the tribunal, and in our opinion rightly. The anomaly and discrepancy of fixing lower pay scale for promotees amounts to invidious discrimination and violates Article 14 of the Constitution. The same post with identical duties and responsibilities ex facie cannot have different pay scales, one for promotees and the other for direct recruits. The difficulty in accepting the plea of stepping up in terms of the clarification dated 13/3/2009 is the second condition that requires direct recruits should have actually joined before any stepping up of pay can be granted. The date of joining would be different, as filling up of the direct recruitment vacancies in the cadre would depend upon vacancy, position, selection, etc. This is unacceptable as it would be fortuitous and even whimsical. In any case, the same post cannot have two pay scales, one for promotee and other for direct recruit, for it violates principle of equal pay for equal work. Stepping up of pay to be granted on satisfaction of the stipulated conditions would not rectify and undo the discrepancy and inconsistency inherent when two different pay scales are stipulated for the same post. When, para 7, when and after initial pay of promotee trained graduate teacher is fixed in terms of the order of the tribunal, increment would be calculated and payable as in cases covered by Section 2 of Part A of the first schedule of the rules as applicable to direct recruits. So, Your Worship,
read the entire thing.
Similar though not identical controversy had arisen before this court in WPC number 8058 of 2015, Union of India versus Malbika Deb Gupta, decided on 4/11/2006. Writ petition of India was dismissed after referring to rule position and illustrations given in the rules. However, we clarified that the dismissal of the writ petition would not have any bearing and does not amount to acceptance of contention raised in some of the OAs which have been disposed of by the impugned order, wherein respondent employees had submitted basic revised pay should be multiplied by the factor of 1.86. So, Your Worship, the Delhi High Court has held that there cannot be two different pay scales for promotees and direct recruits, same cadre. So, when the promotees...
That's what we accept.
Yes.
You don't have to say 20.
And in this...
That we accept. The only problem, the stumbling block that we have right now, we do not know, this judgment does not has not clarified whether there was any challenge to the
Lordship,
we do not know.
I'll take your Lordship to the judgment of CAT. I've annexed that also. In
no,
that
no,
also there was no...
What are the pleadings?
Yes.
You see, what are the pleadings? Is it there? Was it there?
It is mentioned
because you see, there is one thing.
Yes.
There is one thing that is slightly in our mind, is that in the absence of a challenge to the rules, can we pass an order which is not in terms of the rules? Either, you see, if a rule is there made under proviso to 309, either we set aside the rule or we read down the rules. But for that to be done, there has to be a challenge. Only that aspect. We don't talk about the other thing that they should have same pay scale. We agree with you. It's correct. We do not find any infirmity with the decision. The only problem, as I said earlier, is whether we can take a decision in violation of the rules without you challenging the rules. If you challenge the rules, it is okay. But if that is the only
submission with regard to that is even the trained graduate teachers have not challenged the rules.
Two more, even the inspector is getting the two posts. Oh, that's what. The inspector post again will come out. Okay, just one thing. So, so inspector, recruitment to the post of inspector is having two modes also.
SI, sub-inspector.
Sub-inspector is the initial.
Yes.
Sub-inspector is the initial.
Yes.
Sub-inspector is having two modes, direct recruitment and promotion.
Yes.
And what about inspector?
Inspector also has the same.
Two modes.
Two modes.
Two modes, na?
Yes.
So basically, do you mean to say that in the government there are two pay scales for SI and two pay scales for inspector also?
Yes. Yes. Because of the ROP 2008, when pay is fixed on promotion, it becomes lower than the pay of direct recruits. Because of interpretation.
ROP 2008? You talk about ROP
Sorry,
2010.
2010. It is comparable to ROP 2008.
Well, let us hear the other side.
May it please, my lords, if your lordship can come to page 172 of the writ appeal, my lord. The last page, my lord.
Yes.
Serial number 475. Sub-inspector, new entry. 475, my lord.
Yes.
Sub-inspector, new entry, police.
Yes.
The existing pay scale is on 1/1/2006, and the revised pay band and grade pay is there, my lord. And at serial number 478, my lord.
470. Yes.
This is promotee sub-inspector. It's the same pay
Yes,
scale.
promotee.
It's the same pay scale, my lord. 6,500 dash 10,500, 5,500 dash 9,000, pay band 2, 9,300 and 34,800, my lord. It's the same. There's no difference in pay scale.
Then my question is, if it is the same pay scale for new
You
entrants
see,
and
you see, it's not a question of pay, it's the question of basic pay. The basic pay has to remain the same. What you get, the increments that you get because you have been in service for a long time, you'll be getting. That's a different issue. The issue is whether your basic pay is the same, nothing else. Basic pay and pay band should be the same, but the increments will never be the same because your increments will be from probably my brother is earning more than me. Because he came through the service, he's getting more increments. So his basic pay and my basic pay is the same. But he's getting more pay than me. So there are small things like that. It's the question of basic pay.
that is why, as per this, the pay band basic pay is similar for new entrants as well as promotees.
Correct.
But at the time of fixation of pay, the promotee is getting lower pay than the direct recruit. How can that is where the anomaly comes in, Yosh. That is why the Delhi High Court had also said that it should be stepped up.
But they're saying otherwise.
No, they are not saying otherwise.
They are saying that the same basic pay is there.
That then if they have admitted that there is same basic pay, then pay fixation there should be no difference in the pay. But that is what is causing
there will be a
problem.
difference in the pay, but there will be no difference in the basic pay. There's a difference between pay and basic.
If I may take your lordship to annexure 3,
Should be higher. Should be higher. Should be higher. That's what I don't understand. Yes.
Why don't
Why?
you give us a chart, breakup of the pay?
your lordship,
basic plus
if your lordship will kindly
and
see page
comparison.
82, page 82 of the writ petition.
No. You see, let us see your last page
That is why,
certificate from
page 82.
Yes.
Your lordship, this is the LP last pay certificate of the petitioner in the rank of SI.
In the rank of SI.
Your lordship,
This
We'll
is
see.
which date? May 22.
May 22, his basic pay was 57,400. Now, if I take your lordship to page 83, this is his last pay certificate after he was promoted to inspector. And on 31/5/2022, when he was promoted, his basic pay has come down to 55,200 from 57,400.
With refixed?
Refix is, Your Worship, as per the note below, it is the increment.
No.
No, Your Worship, in italics, if Your Lordship will see italics. Promoted to inspector, as Your Lordship got in the middle of the page, in italics. Promoted to inspector of police AB in the level 8 of pay matrix, pay is fixed at rupees 55,200 on 31/5/2022 in the level 8 of pay matrix, and refixed at 58,600 on 1/7/2022 as per option exercise with date of next increment on 1/7/23. So on my promotion, my basic pay has been fixed at 55,200, which
I
is
think
low.
we did some clarification on this. But one thing is very clear. That doesn't take away the fact that we do not know how you can challenge a rule.
No, you
I mean, we can pass an order against the rule without there being a challenge to the rules.
my humble submission, Your Worship, is even the Delhi High Court has directed the
Delhi High Court has said one thing.
step up.
Supreme Court has said that even to read down the rules, there has to be a challenge to the rules.
Your Worship, because
That is why, you see, Delhi High Court can say anything. We can say anything. Any High Court can say. But according to the facts of the case, now we do not know exactly the facts of the case there. What we are trying to say is that there might have been a challenge to the rules in the Delhi High Court case. We
Your
do not
Worship,
know.
I've annexed the judgment of the Central Administrative Tribunal.
But,
There the facts have been clearly stated. There was no challenge to the rules. If Your Lordship will see page 106.
you see, Mr. Counsel, it's very simple. I think you also know it very well. If there is a rule which says that, which says something which is not to your liking, can you expect a High Court to pass an order to your liking in the absence of a challenge to the rules?
Your Worship,
It's very simple. I mean, we do not, just because Delhi High Court has said that, doesn't mean that we have to subscribe to it. Unless you can satisfy us that we can pass an order against the rules. That is, what is the use of the rules? Supreme Court has said so many times that rules should not even be stayed.
my humble submission,
And the first time it was,
I understand Your Lordship's point.
you
But
see.
Your Lordship, this matter went right up to the Supreme Court. Trained graduate teachers.
Maybe,
And
but
Supreme
then
Court
maybe, Mr. Counsel, but the facts in each case are different.
Then Your Worship, if I may take a Lordship.
So
to
maybe
one
those
Supreme-
point was not taken up at that time. We are taking up this point. That time might not have been taken up.
One Supreme Court judgment regarding violation of principles of natural justice. In this case also, the case before the Supreme Court, pay was fixed. Then subsequently, after about 20 years, the pay was refixed and it was fixed at a lower pay. Supreme Court held that such correction of pay is in violation of principles of natural justice and can.
You see, Supreme Court has got the power under Article 142 to do complete justice. High Court doesn't have that. That is the difference.
If I may take the Lordship
You
to this
see,
judgment.
you please enlighten us as to how, under Rule 13, what would be the pay, and under that Rule 15, Table 2, that is already there. Now, because he's saying that Rule 13, they are going to get less basic pay.
Yes, my lord.
Is that correct or not? Neither is he answering that question, neither are you answering that question.
Your Worship, in that matter, page 163, Rule 13 is a bit confusing for a layman. If the respondents can clarify this point. If Your
That is
Lordship
what, and then that is what we are asking you, because you are also confused, that means.
Your Worship, no,
You are not confused.
I'm not confused to the fact that when the pay is fixed under Rule 13 for promotees, it's lower than the pay fixed for direct recruits.
So how much is it? If you are not confused, tell us how much is it?
Your Worship, that I'll have to take into because when my pay was fixed, when I was promoted as SI, it was fixed as per table
Okay,
Rule 15.
okay. So you obtain instructions.
Yes,
You
ma'am.
bring someone. We'll take it up on Monday. We'll take it up on Monday. You just explain to us, you see, first of all, as per Rule 13, what would be the basic pay of this person?
Yes, my lord.
Because there is a calculation there. Let us see the calculation. We also can calculate actually. I'm just wanting to do it quickly, that's all. Page 163.
13.1, my lord.
But there's a clarification, it's quite confusing.
No,
Anyway, Your Lordship will see.
let us try to understand. In the case of promotion from one grade to another, in the revised pay structure, this was done, this is dated, this 2010, correct?
Yes, yes.
One increment equal to 3% of the sum of the pay in the pay band, and the existing grade pay will be computed and rounded off to the next multiple of 10. This will be added to the existing pay in the pay band. Added to the existing pay in the pay band. The grade pay corresponding to the promotion post will thereafter be granted in addition to this pay in the pay band. In cases we need the figures out here.
Yes, my lord.
Your Lordship, 13.1, then there's the clarification also. If
Anyway,
if the finance
we want a clarification.
Yes,
Basically, we want to know what will be the basic pay out here.
Yes, my lord.
But because it appears that the basic pay will be the same, it's only that
The
the pay will be different. That's all.
Yes, my lord.
So his basic case, we want to. So according to you, will the basic pay be different for a promotee and for a direct recruit?
Yes, I've shown you.
I'm asking you,
Yes, Your
is
Lordship.
it?
Your Annexure 3 and 4.
According to you, the basic pay will be different.
Yes, Annexure 3 and 4
How
clearly
can
show
a
that.
basic pay be different?
Annexure 3 and 4 clearly show that.
How can a basic pay be different?
Your Lordship will see Annexure 3.
Page
I just took Your Lordship to page 82.
82. Yes,
This is my basic pay as SI.
page 82.
Yes. Your Lordship, this is my last pay certificate in the rank of SI, and I was getting a basic pay of 57,400. And now at page 83, after my promotion, my basic pay has come down to 55,200, which is lesser than 57,400.
Correct. The appellant has put to challenge the impugned order dated, judgment and order dated 17/10/24, passed by the learned single judge in WPC 89 of 2023, on the ground that the pay given to a promotee sub-inspector under Rule 13 of the ROP Rules 2010 is lower than the pay of a direct recruit
Rule
under Rule 15,
table 2.
Table 2. However, when the writ petitioner / appellant was promoted to the post of SI from
Havildar.
Havildar, SI Arm Branch,
Yes.
SI Arm Branch from Havildar, his pay was not fixed in terms of Rule 13, but in terms of Rule 15, Table 2. Full stop. Next para. The writ petitioner was thereafter promoted to the post of inspector
On 9/5/2022.
on 9/5/2022. and his pay was fixed in terms of Rule 13 of the ROP Rules 2010.
10.
By recalculating the pay he should have received as SI in terms of Rule 13 of the ROP Rules 2010. He submits that the pay of a direct recruit and a promotee in the same grade should be the same and cannot be different. First of all, one question that disturbs us is the fact that there is no challenge to the Rule 13 of the ROP Rules 2010. And the Appellate Council will have to address the issue as to whether we can pass an order in violation of the rules made under the proviso to Article 304 309 of the Constitution in the absence of a challenge to the said rule. List the matter on Monday.
Regarding the clarification of Rule 13.
Yes, I have already told him.
No, I mean, in the order it's not mentioned.
We have told him. We don't have to spoon feed him everything.
If there's one judgment,
Okay, Tuesday. List the matter on Tuesday.
if there's one judgment where the Supreme Court has held that reduction of pay without show cause notice is illegal. 1994.
No, that is all right. That is all right. You see, that issue,
And that's a secondary issue.
that's a different issue.
But Your Worship, in my case also, 2008, 2022, I mean, after nearly 12 years, suddenly they reduced my pay.
More than that, we have got to understand this, what is the actual pay. We have to understand this Rule 13.
And in your CAT judgment, there was no question of any challenge to the rules because it was a clarification that was set aside.
Yes.
That did not involve
Yes.
invalidity of the rule itself. It is just the
They-
on the
yes,
basis
they
of
filed the-
MHRD, they issued a clarification on step.
They filed the complaint. It was the respondents were directed, Union of India was directed to consider the complaint. Then they gave a clarification, which was challenged.
You see, there is the judgment, 3 judges bench judgment, Supreme Court, which says that you cannot even read down the rules if there is no challenge to the rules. So that is what is weighing on our minds. You'll have to overcome
Yes,
that.
even just a humble submission that even if there is no challenge to the rules, but when they themselves say that the pay scale is the same for promotees and
That is why we want to
Yes.
we want to be
at the
clear.
time of implementation, how
Look,
can
the
they?
problem is you are not sure of what is the pay scale to be given under Rule 13, even in the appellate stage.
Your Worship, because at no point of time my pay was fixed as per Rule 13. It was fixed as per.
No,
Table
that's what
2,
we
Rule
want to
15.
know. As per Rule 13, what was the pay scale to be? You should have asked that question to your client and tried to understand, as per Rule 13, what should have been your pay. Then once we have that, then we can go to the next step. No.
I'll also get in
Yes,
touch
you
with
also
my-
get in touch, both of you. What should have been the pay? How do you calculate? What are the basic? I don't think you can have 2 basic pays. The basic pay will remain the same. It has to remain the same. It has to be. I don't think you can have 2 basic pays.
When they have admitted that the pay is the same,
Correct.
how can they fix the pay for a promotee lower than the?
That is one issue. That is why you have got a case. But then the problem is that whether we can mold it to your liking is a different issue, because of there's no challenge, in the absence of a challenge. So you think clearly also, probably you better, maybe you can withdraw and file you challenge the rules itself.
At this stage.
Why not? Because that is not an issue. That is not the issue, na. We can give you liberty to challenge the rules if you think.
Let it come up on Tuesday.
Yes. You think about it, because unless you challenge the rules, it's very difficult. I don't think we can pass an order against the rules. Supposing the rules, the interpretation of the rules turn out against you. If it turns out in favor
Because
of
at this stage, regarding interpretation, they're admitting that it's the same pay scale for promotees and direct recruit. Then how can at the time of pay fixation, the pay of the promotee be lower than the pay of
that's what
direct recruit?
I don't understand. Because
Let them explain that.
yes. We see.
Okay. I would like.
Item number 2.
I think it's getting higher than me. You see, some of the instructors are they don't want to go to the one SP, I mean the DPM. Because they are the same, they're getting higher. Those on the verge of retirement, they don't want to go.
May it please your lordships, we will be appearing in this PIL for the respondent number 14, and we shall file the power and counter affidavit within this week.
Who is 14?
Huabzhou Construction and Consultancy Services.
Yes, madam.
The contractor who is handling Serchhip District Jail, Lordship. That's the one she's referring.
Okay. Okay. Let them know material instructions.
Lordship, we needed some extension to complete the work for the renovation, and we made representation to the government.
Now
and
the
which
thing
was
is that
allowed.
madam, do we continue with this all the time? This case?
Lordship, since they cannot give any up-to-date status, these contractors,
With regard
8
to
contractors.
8 contractors.
Yes,
Achha, there are 8
Lordship.
contractors now.
Yes, Lordship. 8 to 15 were impleaded, Lordship.
Here you will be appearing for which contractor?
Respondent number 14, construction or working upon the renovations of Serchhip
Serchhip
District.
Your name?
Lerinomi Chakchwak.
Ms. Lalinomi Chakchwak, Learned Counsel, submits that she will be appearing for the respondent number 14. Have you submitted a wakalatnama?
Not yet, my
And
lord.
submits that she will submit her wakalatnama within a week.
Yes, my lord.
She also submits that affidavit in opposition will be filed within
This week.
a week. Miss Linda, yes?
Yes, my lord.
What is to be done? Why aren't the other contractors coming?
Yes, my lord. I think they have received the notice. As far as I know, my lord, around 50 to 70% of the work is completed in most districts.
So let the jail superintendents file a report with regard to the percentage of work already done and the percentage of work to be done. Okay. We'll give you some time to file. Just say at least how much is to be done and when it will be completed. So this is for improvement and maintenance of jail, correct?
Yes, Lordship.
Okay, right. The additional AG, Mrs. Linda L. Fambo. Is instructed to obtain instructions and file affidavit with regard to the percentage of work done by the contractors for improvement and maintenance of jails in the state of Mizoram. The same should be done by way of an affidavit, in which it should also be stated as to when the work being carried on by the contractors would be completed. List the matter, give a date. After around, after 4 weeks.
29th of June.
Obliged, Lordship.
Obliged.
Item number 3.
My Lord, in this matter, the leading counsel, Mr. Jonathan, is in this post, my Lord, who is appearing on behalf of the private respondents, my Lord. So I have already informed the other side, my Lord, if the matter may be listed again on the next day, my Lord.
Yes, you have to adjourn.
My Lord, it's pending, my Lord, since long this alia for confirmation. My Lord, similar matters are pending before the principal bench, my Lord. But in this case, condemnation has not been allowed, my Lord. My Lord can give a date, my Lord.
You all have been praying for adjournment all the time.
Not all the time, my
Not
Lord.
all the time, but sometime.
Only last week, last day, my Lord.
We'll adjourn once, give them a chance.
My Lord. Yes, my Lord.
On the prayer for adjournment made on behalf of Mr. Jonathan L. Silo, learned counsel for the respondents number 1 to 69. List the matter.
After 2 weeks, my Lord.
I'll give a date.
17, my Lord.
17.
Obliged.
Obliged.
Item number 4.
No, Silo is there's a 5 name.
4 there, 5 on me.
Lordships,
Probably his judgment.
Your Lordships, I've been requested by the conducting counsel for the appellant, Mr. Priyangshu Goswami, to seek an adjournment for the matter, my Lord.
Why?
My Lord, he said he's having some medical emergency within his family.
Within his family.
Yes, my Lord.
How far? Country cousins or what?
I do not know, my Lord.
Yes, any objection to this delay?
Yours-
That's
yes.
135 days only.
Yeah, we have objections, Your Worship. We have also filed an affidavit. In item 4 and 5. Sure.
So, when do you all want?
My Lord, he asked me to pray for 3 weeks' time, my Lord.
Have you filed your written objection?
Yes, sir.
3 weeks.
Yes, my Lord.
Yes, any objection?
He spoke to us, Your Worship.
We spoke to
Yes,
her.
he's taken our consent, that's why.
Okay, right.
Maybe we can take up your objection and decide.
Your Worship, since he's already taken my consent, Your Worship. He spoke to us last night, Your Worship.
But we are ready.
He's in Gauhati, my Lord.
So,
On perusing your objection, we may find it's frivolous.
I understand, Your Worship. But since he's already spoken to us in advance, taken our consent.
you should have told us yesterday, then we would have left it aside. We do not have to read these files.
Emergency has occurred today, it seems.
Okay, right. On the request for adjournment made on behalf of the applicant/appellant's counsel, which is not objected to by Mr. A.R. Malhotra, learned counsel for the respondents. List the matter. Give a date.
24th of June.
Item 5 also same order.
Yes, my Lord. I'm deeply obliged, my Lord.
Item number 6.
My sincere apologies, Your Lordships. Lordships, I was supposed to mention the item in the morning itself, Your Lordship. I missed the mentioning hours, Your Lordship. Lordship, I am appearing for the respondent number 5 here in Your Lordship, the private respondent, Your Lordship.
No further adjournment,
Lordship,
Mr.
I'm-
Counsel. What is this?
Lordship, I am being led by Mr. P.J. Saige, Senior Advocate, Your Lordship. Today he is indisposed, Your Lordship.
He's in this post
Lordship,
today.
He was here yesterday.
Yes, Your Lordship.
Yes, we saw his
Lordship,
face
we
here.
are- Yes, we are indeed in Aizol, Your Lordship, but the matter is listed all of a sudden, Your Lordship. We are not having the files, etc., Your Lordship. I'm so sorry, Your Lordship.
We'll give you our
Lordship,
file. You see, on the last day, the adjournment has been made on behalf of respondent number 5. Same.
Yes, Your Lordship.
And
However,
then
the matter was not fixed,
on the
Your Lordship.
date prior to that, again on the behalf of respondent number 5, and again prior to that, again respondent number 5. So on
I'm
the
sorry, Your
last
Lordship,
3
sir.
consecutive dates, this adjournment has been made by the respondent number 5.
Lordship, since this is a hearing matter, Your Lordship,
No,
last
hearing matter,
accommodation,
so
Your
what?
Lordship, after,
No.
after vacations, Your
No,
Lordship,
no,
I'm
no,
praying. Your
nothing, nothing like that, not at all.
On a fixed date, Your Lordship, as per Your Lordship's convenience, Your Lordship.
What is the case
After
about?
vacation,
What
Your
is the case about? Yes, what is the case about?
My lord, so this case we are concerned with a post called Superintendent Group B post, my lord, in the,
Yes.
in the NIT. Now they had floated an advertisement for this particular post, and the age limit mentioned in this, my lord, is 30 years.
30 years.
30 years. Now what has happened was the respondent number 5, my lord, he has crossed 30 years. In fact, he was 35 years, 6 months and 25 days old.
35 years, 6 months on the last date of submission
On
of
the last date of submission.
of the applications.
That's correct, my lord. So then
Okay.
what he had done, my lord, he had made a representation, and in his representation he had asked for 5 years relaxation
5 years relaxation.
on account of him being a departmental candidate.
So that can be allowed.
That can be allowed. Now what happened is, my lord,
So
in
that
this-
still he doesn't.
we are not aggrieved, my lord, by this.
35.
6 years
But
again.
still he becomes 35. So he's still over.
He's still over. Now what happened, my lord? We filed this case. We came to know about this much later, my lord, after he was appointed. Like
Okay.
one. Then we filed the case. Then, my lord, in their affidavit, in the respondent number 5 and the NIT affidavit, my lord, for the first time, they had mentioned one new relaxation that was given to him. My lord, this was never part of the representation or part of the records. They had mentioned one new thing. They say, my lord, that since he was a scheduled tribe, he could get another 5 years relaxation. So he was given 10 years relaxation, basically, my lord.
For scheduled tribe.
Yes, for scheduled tribe. So he was given 5 years as a candidate and another 5 years as a scheduled tribe. So he became 40. He was given
10 years.
10 years relaxation. So the basic issue is, my lord, whether this is legal, my lord. That is the basic issue.
There's no other issue.
The other issue we have is, my lord, with respect to his degree and all of those things, which we can touch upon, my lord, later. But the basic issue, the first argument, my lord, is with respect to this, whether he can be given to.
So what is your case?
My lord, firstly, our argument is this, my lord. The argument is he had asked for 5 years relaxation.
And he had asked for 5 years, and the department gave him 10.
No, let's put it this way. He had asked for 5 years, my lord, and this 10 years relaxation never appeared in any of the records. So till before the exam, he was only given 5 years relaxation.
Whatever it is, the first question is,
Yes,
he asked for how many years relaxation?
5 years.
He did not ask for 10.
He did not ask for 10. So that is the first. And the second is, my lord, the law itself is like that, my lord, that you cannot give 2 year double relaxation, my lord. Now, my lord, my humble request today, my lord. Of course, my lord, I'm not asking for adjournment. Since they have asked, they have requested. Can we do this, my lord, on Monday?
We can do it today also. If they don't want to come,
Because,
they
my
can
lord,
go
there
to
are-
Supreme Court.
Yes, because
Lordship,
You are there.
it will be, Lordship, it will be difficult, Your Lordship, in this week,
Mr.
Your
Bilal
Lordship.
Menga is there with the file. Your father is
Lordship, certain nuances, Your Lordship.
No, you
Senior
cannot keep
counsel
on
would like to highlight,
you
Your
cannot keep on adjourning the matter just 3 consecutive times. You could have told us yesterday. Why today? You know of the you are from
Lordship,
Gauhati, correct? You are from Gauhati, correct?
Yes, Your Lordship.
You know
Yes, Your
the
Lordship.
notification in Gauhati that you have to give
Lordship.
us one day in advance. What do you
I'm
think?
sorry,
What
Your
do you think we
Lordship,
do before coming to court? You think we watch Netflix? I could have done that.
Lordship,
we
the
come
consent of the other side
prepared, we
was
study,
obtained,
we
Your
come
Lordship.
prepared, and you have adjourned this matter on 3 consecutive dates.
Lordship, the cause list was out later in the evening, Your Lordship. We weren't
Maybe.
in a position
That
to.
is how it has been going on here for the last 20 years, 30 years.
I'm sorry,
That
Your
is how
Lordship.
the cases
I'm
have been
sorry.
listed here in Aizawl.
I'm sorry, Your Lordship.
We
Lordship, last opportunity,
we cannot
Your
list the
Lordship.
cases as your wish, as you want. You have to
Lordship.
you have to follow the procedure that is being
Lordship,
followed
the
here.
respondent number 5 is still serving in the same post, Your Lordship, and Lordship, there is no such urgency as such, Your Lordship. If I may pray, Your Lordship, immediately
Yes.
after
No, there is
vacation, Your
urgency
Lordship.
on
Put him off for the time.
Your Lordship, with apologies, my Lord.
Yes.
Although my name is also appearing for respondent number 5, but I am led by the senior counsel, in fact.
I know.
So-
He doesn't want to come, we cannot help it. Yes.
So, my lord, the advertisement My lord, the advertisement is at page number 131, my lord.
Page 31.
131,
Yes,
my lord.
131.
Yes. Now this is the advertisement. Your lordship will see. My lords will see at page number 131, a serial number 2.
Yes.
My lord, serial number 2, if your lordships will see, it says not exceeding 30 years, in fact.
Correct.
Now, if your lordship will come to page number 283.
Is for superintendent group B.
Group B
correct?
post, my lord. Yes, correct.
Then page 100, page
Now, 283, my lord. (283). This
no,
was
I didn't tell him that you should, I just wanted him the volume off. Let him come, let him be there. Let him be there. Only the volume should be off, not him. I didn't want to shut him out. That was not my intention. I just said that put his volume off. Because he's only asking for time, that's all.
Now, your lordships will see this is the representation he had submitted after he had made the application, 283, my lords.
283, yes.
Yes, this was via email. It says, my lords, request for reconsidering my application for the post of superintendent at NIT Mizoram. Now, it reads, my lord, the second paragraph is important. I'll read the second paragraph, my lord. On the only probable reason, says, for rejection of my candidature might be on the ground of being overaged. If this is the case, I earnestly request you to please revisit my application referring to the DOPT order on information document on grant of relaxation of upper age limit, point number 5, 5.2, annexure 1, which states that age concession of 5 years are allowed to departmental candidates, central government employees, in case of recruitment to Group A and B posts, which are filled through UPSC other than those filled on the basis of competitive examination, and posts which are exempted from purview of UPSC, where recruitment is made by organization themselves. This concession is admissible to such of the government servants as are working in posts which are in the same line or allied cadres, and where a relationship could be established that the service already rendered in a particular post will be useful for the efficient discharge of the duties of post. Now, this memorandum, my lord, he has enclosed, and it is in the next page, my lord, 284. So basically, he has asked
Just
for
a
only.
minute.
Yes.
This is for grant of relaxation to various categories. So where does it say about departmental candidates? Out here it also talks about SC/ST.
Yes, SC/ST, but he has asked only for departmental candidate. My lords will see 285.
285.
286, in fact, my lord, 5.2. Age relaxation of 5 years. So he has quoted that.
285.
285. 286.
286.
286, because it goes on 286, 5.2, my lords.
Okay.
Age relaxation of 5 years.
Page 284 and page 286. Yes.
Now, so he has asked for that, and his representation was considered according to him, even though there is nothing that says his representation was considered.
Page.
Well, no, there is nothing in the record. They don't have anything in the record that says his representation was considered and allowed. That is not there.
Oh, that's not there.
That's not there. It's there in their affidavit. They have mentioned that it was considered and allowed. That's all. That's all that's there. Now, this 5 years relaxation given to him, my lord, is the basic challenge that we have made. And now our contention basically, my lord, in the writ petition as well was this, that after this 5-year relaxation, he's still overage, and therefore he could not have been allowed, my lord. Now, in their affidavit, they have come up with another notification, my lord. This is at page number 297. This was the representation submitted by respondent number 5. This entire thing, my lord, was not there in the records only. Even in his representation, it was not there. But 297, lordship will see.
Yes.
Now this is with respect to this was a notification of 1974. Your lordships will see the first one,
Yes.
scheduled castes and scheduled tribes. All posts filled up by direct recruit, 5 years. So now what they are saying is they can enjoy this cumulative benefit of 10 years because there is another notification which allows them for another additional 5 years.
But this one also allows them anyway. 284.
284. Now, my lord, there is a full bench judgment of the Bombay High Court. It's a Bombay High Court.
Well,
1 minute. We have Bombay High Court judgment.
Five years average concession. This is a direct recruitment post.
This is for direct recruit. And my lord, there are Supreme Court judgments also, my lord, which says that if a post is not a reserved category post, my lord, because scheduled tribe post reservation is usually when the post is, if the post is not a reservation post, my lord, that reservation cannot be applied to that post. There are Supreme Court judgments on these lines, my lord. And there's a Bombay High Court judgment, full bench judgment.
No, but you see, does it mean that if you avail of these benefits granted to a scheduled caste or scheduled tribe, you cannot compete for a general category post? I don't think that's
No, not like this, my lord. What I'm trying to say like this is like this. My lord, supposing there's a post like this post, my lord.
Yes.
Which is a general category post.
Yes.
It is the post, my lord, which can be applied by everyone. It's only one single post. Now this general category post, when it's a general category post, my lord, there's a judgment which says that you cannot use reservation when it's a general category post. If the post,
there is existence in reservation, you cannot
yes, supposing, my lord, let me put it this way. Supposing there are 5 posts, my lord, and 2 of those 5 posts have been earmarked for reserve category post. Then, my lord, you can apply as a reserve category for those 2 posts.
I don't think.
Anyway, my lord, this is one of our ground of our submission, my lord. And the second submission, my lord, we have was the Bombay High Court full bench judgment, which says that, my lord, cumulative benefit cannot be given, cumulative reservation cannot be given unless the rules memorandum specifically mentions that it can be given. So this is another Bombay High Court judgment. But, my lord, let me say this, my lord. I have been put in a very inconvenient situation because I was informed last night that they were going to pray for time. So, my lord, if it's possible to do it on Monday or Tuesday, because even we want to do it quickly, my lord. But
then, okay. Anyway, let us see. Where is the advertisement page?
My lord, the advertisement was at page number
131.
Yes, 131, my lord.
No, you see out here,
yes,
at page 134,
yes,
clause 14, provides that SC/ST candidates application they should submit the certificate.
No, because there are some posts My lord, if I'm not mistaken, there are some posts which have been made
So
for
the thing is that in his application,
Yes.
he might have submitted the SC/ST.
No, Your Lordship will see
certificate.
number 4 in page number 131. This is just one example, my lord. Page number 4, serial number 4, my lord. Triple E, Your Lordship has seen DEEE. This has been specifically earmarked for OBCs.
Where?
My lord, at page 131.
131?
One, yes. This is just one example, my lord. Number 4,
Yeah.
technician group C.
How does it matter? No, I think they can avail. Otherwise, what is the purpose of having this SC/ST relaxation? That is no bar. That is no bar.
In the absence of any express prohibition.
Yes. No, because the Bombay High Court judgment says like this, my lord, that there has to be.
Indian law. So where does it say that cumulative cannot be given? Let us see the Bombay High Court judgment.
My lord, that's the thing, my lord. I'm very. I've been put in a very awkward situation.
Express provision allowing for to cumulative. Right. So if both of you are unprepared, what to do? On the pair of the parties, list the matter for hearing.
Lordship, after vacation, Your Lordship.
My lord,
if possible.
my lord, on Monday, because
Since it's a hearing matter, Your Lordship.
When do we do it? Not before, it's before vacation. Huh? No, we can take it up. That's not an issue. If we are here, we can take it up. Only problem is Jackson will not be able to take it up. That's it. No, we can do it at the end of this month. Just give me the roster. It's on my desk. Roster. On the prayer of the party, list the matter on dash. I'll give you the date later. First up. It is also noticed that the respondent number 5 has taken adjournments. List the matter on 30. It's a holiday, I think. 30 is a holiday, no, 30 is a holiday. List the matter on
Next, when is
1st July.
hearing date? DVD.
During the vacation.
1st
Leave your
July.
place.
1st July. 1st July.
Leave your place.
Item number 7.
Item? Supplementary. Hearing mo? That
This is
matter.
yesterday's case, my lord. My learned friends.
That DNA testing.
Okay, let me see.
Why did we adjourn the matter? Because you were not ready.
Yes, my lord. The course list we have been informed this morning only.
No, last time, why did we adjourn this matter?
Last time, why did we adjourn this matter?
If your
Yeah.
Lordship will allow me to mention, Your Lordship, that yesterday's matter where we were requested to submit the list of material exhibits.
Which item? What was
Item
that?
Part 2, Item 1. Yesterday,
Regarding?
appeal under the Prevention of Corruption Act.
Ha ha.
The material exhibits were not annexed to the paper book.
Ha ha.
So we have made out a list. So these can be included in the paper book. These are the material exhibits which the trial court had relied upon.
So they can have a separate paper book for this.
For this, yes,
Right.
Item 1, Part 2.
Item 1, Part 2. Heard the counsels for the parties who submit that the following material exhibits are not part of the paper book. Then you just take 1 to 11. See this one, 1 to 11. They submit that the registry may furnish a supplementary paper book and consisting of the 11 paper books, 11 material exhibits mentioned above.
Series of 11.
A series of
11. In some there are 5, 6.
It doesn't matter. 11 material exhibits mentioned above. Registry is directed to make a supplementary paper book and in respect of the above mentioned material exhibits and provide the same to the parties within.
My learned friend is also there.
Within
2 weeks?
Within 2 weeks. Within 3 weeks. Maybe. Within 3 weeks. List the matter thereafter. Take this. Give it to them.
Mumbai.
For motion item number 1.
My Lord, this is an application filed under Article 226 of the Constitution of India, challenging the illegal action of the respondents number 6 and 7, who are the YMA Venglai East branch, and the petitioners and her family were forcefully evicted from their residence on the night of 18 May 2026, my Lord, on the ground that they were involved in selling some country-made liquor, my Lord. So till date, they have no place to stay, and they were staying in their friend's house, my Lord, in the neighboring locality, my Lord. And my Lord, in fact, my Lord, at page 22, they have made press statement, which is in Mizo vernacular, my Lord.
Right. Yes, madam, what is to be done here? Have you filed any FIR?
Not yet, my Lord.
Have you any
the-
complaint to the police? Nothing.
She went to the SP, and she did not receive any good response from the SP, my Lord. She's approaching the SP.
Heard. Mr.
H. Zaudin Sangha, my lord. Legal Aid Council.
Learned Counsel for the petitioner.
Legal Aid, my lord.
Learned Legal Aid Counsel for the petitioner, who submits that the petitioner and her children
Family, yes, like a son and the grandson.
and the petitioner, her son and grandson.
Three children and one grandson, my lord.
Say that.
Yes.
Any daughter-in-law, anything?
She had 3 sons, 1 daughter, and 1 grandson, my lord.
Anybody else?
Nobody else.
Okay. Nobody else, no?
Yes.
Who submits that the family of the petitioner, consisting of her 3 sons, 1 daughter, and 1 grandson, have been evicted from their house located in Venglai East locality,
Yes.
Kolasip, by the respondents number 6 and 7. By the respondent number 6 and 7. Further, a press statement dated
Date was not mentioned, my lord.
a press statement dated nil had been issued by the YMA Venglai East Branch, Kolasip, stating that they would not allow the petitioner and her family to stay in the said locality on account of they being liquor and drug sellers. Full stop. The counsel for the petitioner submits that the immediate reason for eviction of the petitioner and her family was due to the fact that 30 liters of local liquor were allegedly recovered from the house of the petitioner.
Not my
No,
lord.
no, no, no,
not
no.
rented langsam.
Were recovered from
Rented langsam, my lord.
were recovered from an area outside Kolasip town,
Yes, my lord.
which belonged to the petitioner. The petitioner's counsel submits that though the petitioner had approached the SP with her grievance, the SP Kolasip did not give much attention to the complaint made by the petitioner. Issue notice returnable in 3 weeks. Petitioner, Miss Caroline K. Lungoipui, GA, accepts notice on behalf of respondents number 1 to 5. Petitioner to take steps for service of notice upon the respondents number 5 and 6.
6 and 7, my lord.
6 and 7
Yes.
by speed post and by usual mode within 2 days. Full stop. it is quite surprising to find that even today the respondents number 6 and 7 are acting as extra constitutional authorities by taking the law into their own hands. Yes, sir. Without taking the law into their hands. Yes, sir. Accordingly, in view of the seriousness of the issue raised by the petitioner, the respondent number 2 and 4 are directed to make a report with regard to the incident and inform this court as to what steps they have taken to ensure that the petitioner can return. The petitioner and her family can return to their residence, which has apparently been kept under lock and key.
Yes.
By?
The respondent number 6 and 7, my lord.
By the respondent number 6 and 7.
My lord, if you look at the photographs,
yes,
it's in page 24, my lord.
Yes.
They have took out all their belongings from their house after eviction.
Further, the photographs at page 24 of the writ petitions show that the belongings of the petitioner and her family have been taken out and kept outside the house of the petitioner. The respondents number 2 damage is caused to the house of the petitioner. List the matter on. Give a date. 2 weeks, no?
My lord, if interim order may be passed to return back to their house immediately, my lord.
Let us get a report first.
Okay, yes, ma'am. Since they were staying in the nearby locality with
the affidavits to be filed by the respondents number 2 and 4 shall also contain the steps to be taken by the respondents number 2 and 4 to ensure the return of the petitioner and her family
in their premises
to their residence.
List on 25th of June.
Obliged.
25th, why? Today is what date?
3 weeks.
2 weeks, 2 weeks.
2 weeks, yes.
On 18?
Oh, it is 3 weeks. No, notice has
Yes.
notice has to go to them.
Yes.
So it will take some time.
Yes.
Okay.
Item number 2.
Lordship, I'm appearing on behalf of my senior for the respondent number 5, my lord. He's the standing counsel for the tourism department, my lord. And my lord, even though this court in its last order had given last chance, my lord, verification is currently being awaited, my lord, and we'll be able to file our affidavit within the course of the day, your lordship.
By today?
Yes, lordship.
Okay, Miss, your name?
Daphne Shwaitlongi, my lord.
Huh?
Daphne Shwaitlongi, my lord. On behalf of
Daphne Shwaitlongi, appearing on behalf of
JC Lanunsanga.
JC Lanunsanga for respondent number 5, submit that affidavit will be filed today. If not filed, it's no more a joking matter, madam. Please remember that.
Yes,
List the matter tomorrow.
Item number 3.
May I seek your Lordship indulgence? Lordship, I've been requested by Mr. Tila Zakima, counsel for the appellant, that he has some personal difficulties, so if the matter can be kindly fixed on Monday.
On the prayer for adjournment made on behalf of Mr. Tila Zakima, which is not objected to by the other side, list the matter on Monday.
I'm duly obliged.
Item number 4.
Please, Your Lordship. My Lord, this appeal is filed against the order of the Learned Additional District Judge, Aizal, my Lord, for judgment order at 1/7/2025, my Lord. In the award was passed in favor of the respondent contractor, and we filed a section 34 application before district judge, additional district judge Aizal, challenging the said award. Our only very limited the challenge was the 10cc. Clause 10cc is not applicable in this contract. That is
what
the
is clause 10cc?
10cc is, there is the 10cc includes the price escalation of labor plus cement plus steel plus materials.
Can we go into those issues?
My Lord, because the agreement itself specifically it is deleted. Agreements deleted specifically. So this has to be examined by Your Lordship. So at this stage, may I pray to issue notice, my Lord, and fix for hearing the...
unless you convince this court.
Yes, my Lord. Yes, my Lord.
I am
Yes,
not going to issue any notice.
Yes, ma'am.
Right now, you have got to convince this court that why should not this arbitration appeal be dismissed?
Yes, my Lord. This, my Lord, so far this one clause is there, my Lord. Where is this
10cc?
10cc, my Lord, is specifically. Yes, my Lord. This when arbiter passed award, my Lord. My Lord, is specifically, my Lord, is in page 70, my Lord, 70, my Lord, 70, my Lord. Para 83. My Lord, what happened, my Lord? This when the contract agreement was signed, my Lord. Just
a minute, Mr. Counsel. Just a minute. Let me read.
Yes, my Lord. Yes, my Lord.
Page 70, page 83 is what is it? It's not 10cc. It's only about the arbitrator's award or what?
Yes, my Lord. Yes, my Lord. Lordship is if Lordship 10cc is, my Lord, specifically, my Lord, mentioned in the my Lord is this is a contract, my Lord. This is a contract, my Lord. It is, my Lord, page 542, my Lord.
No, what is your challenge? What is your challenge to this award? You tell me fast, because I'm going to dismiss your case otherwise. I don't find any case.
Yes, my Lord. My Lord, what happened, my Lord? When the agreement was made, my Lord. Agreement was made between the parties, my Lord. There is specifically there is mentioned, my Lord. The 10cc is not applicable in this when price escalation is there, my Lord. Only 10c and 10ca will be applicable, my Lord. It is specifically mentioned.
Where?
So far, this I'm coming, my Lord. The contract agreement this starts from 386, my Lord. Contract agreement, my Lord. 386. 386, my Lord. 386.
Yes.
And my Lord, Lordship may turn is written clause 10cc.
There is no 10cc.
My Lord,
10cc, yes.
10cc in right side, 10cc is deleted, hence not applicable. And next page here, next my lordship may turn page 400, 400.
Yes.
The clause 10cc is there, left side, and right side is not applicable.
Okay.
Here, my lord, when arbitrator pass award, my lord, the arbitrator, my lord, calculated the price escalation as per 10cc. 10cc is, my lord, my lord, 10cc is this, my lord, I'm coming, my lord, 10cc. 10cc, my lord, is reflected in, my lord, page 542.
Just a minute, let me see. Page 83, what is there?
Page 83.
No, not page 70, page 70.
Page 70. Page 70, my lord, when the 10cc is, my lord, this, as per this award is concerned, my lord, the price escalation was calculated as per 10cc, my lord.
That is only the claimant had calculated.
Yes, my lord. Yes, subsequently, my lord, made this lordship may page 72, my lord. 72.
Yes.
This is the calculation, my lord.
Yes.
So, my lord, award was passed.
So what is wrong with this? What is wrong with this calculation?
My lord, this calculation
under 10cc. Okay. It's
so
made
when
under
10cc is delayed, yes, my lord. That is the case, my lord.
So price escalation has been made under 10cc.
Yes, my lord. 10cc, my lord, says, my lord,
it's not applicable.
Yes, my lord.
And that is the award. Now, what about the judgment of the civil court page?
Civil court judgment, my lord. This is, my lord. It starts from, my lord, annexure A, page 15, my lord. Findings, my lord, starts from page 32, my lord. So for
just a minute.
Page 30, yes, ma'am.
Page 32.
Page 32, my lord, this analysis and findings, my lord, of the learned Judge below, my lord. And page 32, my lord, paragraph 21, my lord.
You mean 10cc cannot be applied at all in the
Yes,
entire?
sir, as per agreement, it is deleted, my lord.
Huh?
As per agreement, my lord, it is deleted, my lord. So it is not applicable, my lord. These are submission before the learned arbitrator as well also before the learned court below also, my lord. So that has to be examined, my lord.
Okay, right. Right, Mr. S.K. Medi, learned counsel for the appellants. First time. This is an application under section 37, appeal under 37 of the Arbitration and Conciliation Act, Common 1996. Hereinafter referred to as the 1996 Act. Wherein the appellant was given the contract for what? Contract for what?
My lord, construction
for
of AG
construction
building
of the AG office building,
yes, my lord,
including
Aizawl, my lord.
development of site at Aizawl. Full stop. So the contract was terminated or what? Completed?
My lord, it is completed, my lord.
But
Completed.
then your problem with the payments, correct?
Yes, my lord. Yes, price escalation price, my lord. That price, my lord. Only the 10cc part, my lord.
Though the contract work had been completed, a dispute arose between the parties regarding the price escalation cost payable to the respondent. The dispute was referred to an arbitrator who page 70. Passed an award dated
9/8/23.
9/8
2023, my lord.
2023.
23, my lord. Page 86, it is reflected, my lord.
By awarding cost escalation and calculating the same under clause 10cc of the contract agreement executed between the parties. The appeal filed by the appellant before the learned civil court under section 34 of the Arbitration Act was also dismissed while judgment and order dated 1/7/2025 passed in arbitration number 5 of 2023. The appellant's case is that as clause 10cc of the contract agreement had been deleted and was not applicable for deciding the dispute between the parties regarding the cost escalation price payable to the appellant, respondent. which is clearly seen, seen in pages
12, my lord, on 398
398
and 400.
and page 400 of the appeal, comma.
This is a part of the agreement.
Cost escalation has been calculated under clause 10 CC. So, he submits that the same would amount to what is that? Give me the Arbitration Act. Arbitration Act.
Section 28, 3, my lord. Section 28, 3, my lord says, while deciding and making award, the arbitral tribunal shall, in all cases, take into account the terms of the contract and trade uses applicable to transaction.
What have I said? Amounts to. Page?
My lord?
Page? That 28.3 you said?
My lord, is in Act itself, my lord. Arbitration Act itself, my lord.
In the Arbitration Act?
Yes, my lord.
28.
Section 28.
Yes. What have I said? Amount to violating Rule 28 bracket 3 of the Arbitration Act.
Yes, section, my lord. This rule, not rule.
Section 28.3. Section 28.3 of the Arbitration Act. And the contract agreement signed between the parties. This is full stop. The same would tantamount to the award being in conflict with the public policy of India as provided under Section 34 of the Arbitration Act. In terms of the judgment of the Supreme Court in Songyam nothing I can say. Issue notice returnable in 4 weeks. Appellant to take steps for service of notice upon the respondent by registered post with by speed post and usual mode within 3 days. List the matter on after vacation.
Item number 5.
Please, Your Lordship, I am yet to receive the PROCEEDINGS comment from the concerned department. This is with regards to challenge of the assessment and 15% cess deduction. So, Your Lordship, if I may be given another at least 2 weeks' time for filing the same.
Yes.
Lordship, I'm for the respondent number 6. We have received the PROCEEDINGS comments and we will be filing it.
When?
Within this week.
Okay. Miss Marielle Kente, Leonard GA, submits that she has not received PROCEEDINGS comments. I am praised for 3 weeks' time to file the same. Mr.
Jonathan Lalrin Luanga.
Jonathan Lalrin Luanga, appearing for respondent number
6.
6.
Yes, Your Lordship.
Submits that he will be filing affidavit in opposition within a week.
Yes, Your Lordship.
Miss?
Lordship, I'm for respondent number 1 and 2. We will not be filing affidavit in opposition.
What is your name, madam?
Baby Laldin Zwali.
Miss Baby Laldin Zwali, appearing for the respondent's number.
On behalf of my senior Central Government Council.
Appearing on behalf of Mr.
Miss
Name?
Iram Sangpui.
Lalun Sangpui.
Miss Iram Sangpui.
Iram Sangpui, CGC. Counsel for the respondents number 1 and 2 submits that the respondents number 1 and 2 will not be filing any affidavit. Mr. Walsheza. Yes.
Respondent number 7 is already filed.
Additional AG submits that affidavit has been filed on behalf of the respondent number 7. List the matter on. Give when? After vacation. After vacation. Give a date.
13th of July. Item number 6.
30th.
Item number?
Your Lordship, this is a matter, adjudication of the matter. And thereafter, the matter was fixed on 20/4/2026. On that day, another 3 weeks' time was granted. And today, the matter is being listed. If the Revenue Department is going to have its response, it may be directed to submit the affidavit within a specified time. Otherwise, the matter is being protracted. Respondent number 2.
This is a writ petition.
Yes, Your Lordship.
What are you challenging out here?
We're challenging the validity of the order passed by the Learned Trial Court and the orders which have been passed by the Learned Trial Court have been obtained by the respondent number 5 by suppressing material facts and by playing fraud upon the...
Which is the order you are challenging? Page?
74. Page 74. This is an order passed in eviction suit number 4 of 2019.
This eviction suit is based upon some civil suit? Where is that civil?
No, it's not based upon civil suit.
It's not based upon civil suit. What is it based upon?
It's based upon the title.
Yes, whatever title suit or civil court case. This eviction suit is based upon what?
Illegal occupancy of my land by
No,
the...
no, eviction suit is based, there must be some other suit first. Achha, this is an eviction suit.
Eviction suit.
Eviction suit, achha. So this eviction, Mr. Counsel, you cannot challenge a civil court order in a writ petition.
That is the...
That is the law.
The law that has been laid down by the Pex Court
Yes.
in the case of
Surya Devi.
Evi Papaya Sastry. That is in 2007 for SCC.
2000?
4 SCC.
So there are judgments.
2007.
There are judgments after that. There are judgments even this year, last year also.
Yes, Your Lordship. There are some other judgments also. 25 in Vishnu Vardhan, alias Vanu Vishnu Pradhan.
I think Sandeep Mehta.
That is 2025 SCC online.
Justice Sandeep Mehta, correct? Justice Vikramnath and Sandeep Mehta, is it?
Dipankar Datta.
Dipankar Datta.
Yes.
So what does he say? What is this? What do they say?
Your Lordship, because of fraud, the order that has been passed by a civil
Fraud
by
that
a
is a
court.
different thing. The procedure cannot be. You cannot violate the procedure. You have got to
Yes,
go.
this is what I was also thinking. But
You have to
Your Lordship,
withdraw this. You withdraw this,
Your Lordship.
and you file an appeal. That's all.
Well, in that case, an appeal has already filed before this court. And
Appeal already filed.
And it has been dismissed, my lord.
Dismissed. Then he's got no case.
Yes, my lord. And he's
Your Lordship,
appearing before this court in disguise of an appeal. A writ petition
A
disguise.
second appeal.
Not a second appeal, it's a writ petition.
No, there was. So this writ petition is a second appeal
Yes,
in
my
a way.
lord. It's disguised like that. The provisions are 226, but...
Let us see the earlier order. The
Your Lordship, why I
appeal
have filed this writ petition is because of the law laid down by the Pex Court.
I know that that fraud vitiates everything.
Yes.
Yeah,
And
that-
here it says that...
But that
it
cannot
can be-
apply. That cannot
No.
apply here.
It is thus settled proposition of law that a judgment, decree or order obtained by playing fraud on the court, tribunal or authority is a nullity, and non est in die of the law, such a judgment, decree or order by the first court or by the final court has to be treated as nullity by every court, superior or inferior. It can be challenged in any court in any time, at any time, in appeal, revision, writ, or even in collateral proceedings. This is the law laid down by the Pex Court.
No.
It has not been modified.
No. I don't think. Just show me that.
Since today it has been fixed for submission of the affidavit by the
No.
Revenue
We'll go by the law, not by the.
yes. We have to go by the law.
Correct. You see, but it depends. That does not mean that a civil court decision can be challenged in a writ. If there is a fraud played, you can challenge it in a writ. But once you have taken the civil court route, you have to follow the civil court route. You cannot jump trains or hitchhike on another stage wagon in the middle of the race. That cannot be done.
Lordship, this is my understanding of the law laid down by the Pex Court.
No,
Let
you
this
know
matter
better.
come up tomorrow.
No problem. We'll
go for final hearing.
Yes.
I mean, subject to
And
the
then we will have it tomorrow, no problem. And you have filed an appeal earlier against this order.
against the order, but appeal was filed before the district court, district judge.
Before
That
this
was
court also.
withdrawn because it was said that the district judge court did not have jurisdiction. And thereafter, appeal was, RFA was filed before the
This
single
court.
bench of this honorable
Then
court.
what happened?
And because of delay, it was rejected. Condonation was not granted. And the matter, there was no,
End of the road.
adjudication, no adjudication of the matter.
Then no, but what does the Supreme Court say? When your condonation of delay application is dismissed, and you file an appeal against that. You cannot play around with the court like this in the manner you're trying to do. This is wrong.
Let me see. This is my humble understanding of the law.
Your humble understanding is, I don't think you're being very fair to yourself. I think you know very well that this cannot be done.
When the very apex court in its judgment said that it is a nullity.
You see, but once you have taken a particular route, you have to go
I have not
that
taken
route.
it. I have not taken any
You have.
route.
You have gone in appeal.
It is the other side.
You have gone in appeal. You are the one who went in appeal. He didn't go in appeal.
Yes, that's true.
Then your appeal has been dismissed by this court. And now you want to come in the writ petition. How can that be? That is not even allowed. In fact, you cannot even challenge a civil court order in a writ petition. 227 maybe, but not 226.
Even by a revision?
No,
or
not when a first appeal has been dismissed by a high court. No. Then your route is clear. Then you have got to go that civil line route. Then you have got to go right now to Supreme Court. That's the only way out. SLP.
And, if Lordship, it has been clearly stated that even by revision, under 227, when an application under 226,
no. You see, you have already taken that route, that appeal route. When the appeal route has been blocked, then you have to follow that route only. You cannot go now jump lanes. Supposing you run in a 100-meter race with Usain Bolt, you cannot now cross into his lane. You have got to go on your lane only. Otherwise you'll cause havoc on the entire race. It's very clear. We can take it up tomorrow, but the writing is pretty clear on the wall. Okay, right. Heard Mrs. Sheila Ramzawa, the learned senior counsel for the writ petitioner. And Mr. Samuel Valathia, the Changte, learned additional lady. Mr. Rosang Zwala appears for. Are Rosang Zwala or Rosang Zwala?
Rosang Zwala right there.
Rosang Zwala appears for respond number?
5.
5. Full stop. The writ petitioner has put to challenge the order dated 26/2/2020, passed in eviction suit number 4 of 2019 by the Court of the Senior Civil Judge Roman 3, Aizawl District, Aizawl. Full stop. It is also stated at the bar that the same order had been put to challenge initially before the district judge. Court of the district judge. Wide, what is the case number? Wide?
RFA number 20 of 2020.
RFA number?
20 of 2020.
RFA 20 of 2020.
Arising out of eviction suit number 4.
No, full stop. However, the learned district court, the learned district judge, Aizawl, rejected the same.
Yes, my lord.
Rejected the same on the ground that it did not have the jurisdiction The pecuniary jurisdiction or what? Pecuniary jurisdiction to entertain the appeal. Accordingly, the writ petitioner filed a regular first appeal against the said impugned order dated 26/2/2020 in eviction suit number 4 of 2019 before this court, in the High Court,
RFA 27/2025.
RFA 27/2025, along with a condonation of delay application. Full stop. However, the condonation of delay application was rejected by the High Court. Without taking any further steps, without doing anything beyond, full stop. Thereafter, the writ petition has been filed by the petitioner under Article 226 of the Constitution, challenging the same impugned judgment and order. And the impugned order dated 26/2/2020, passed in eviction suit number 4 of 2019. On the prayer of the petitioner's counsel, list the matter tomorrow. Difficult matter, Mr.
Item number 7.
And the Chinakati, come on, Sangyong, come on, 2019, 15 SEC, 2019, 15 SEC, 131, no? Yes.
At the last time of the order, the service was due. We have done the service, and the service affidavit has also been filed.
What is the challenge here?
The challenge is towards the escalation of the price rate.
Without any
evidence.
reason.
Without any evidence.
Forget evidence, without any reason.
Without any reason, yes, my lords. My lords, basically the Kala has determined the rate as per section 26 of Right to Fair Compensation Act, and he has described every step and procedure as determined under section 26. However, the learned arbitrator has misinterpreted how to define the market value of land and used the interpretation of the Apex Code like in 70s, 80s, which was based on Land Acquisition Act. So based on that premises, has arbitrarily escalated the price, and the escalated price is without any substance.
Let us see that. If that is your only case, let us see what are the arbitration awards say.
Yes, my lords. My lords, that page 148.
Yes.
My lord, may come to page 151, para 6.2.
Yes.
As regard judicial case studies, though the matter emerged out of determination of market value under 1894 Act, all the judgments that they have relied upon, the requirement prescribed under section 26 of RFCTLA-RR Act 2013 by and large have been addressed in various judicial pronouncements discussed herein. The guiding principle in these judicial pronouncement would have constitute decision factor to address the issue on hand. The apex court in Thakur Kuldeep Singh versus Union of India held that the factor to be considered were delineated as per the nature of land, its suitability and nature of use, to which the land was sought to be acquired on the date of notification, income delivered and derivable form, and any other specific disincentive feature which the land was possessed of, and the sale transaction in respect of the land covered by the same notification. And my lords, may come to the conclusion, operative para 7.1, which is at page 152, my lords. Having considered all the relevant and the comprehensive criteria elaborately discussed above, and also kept in view the genuine grievances of the applicant to see that their lives and livelihood are not severably impacted due to the land acquisition proceeding, the market value of land adopted for determination of payment of compensation in respect of coercive district shall be as under. And my lord has revised the price. Now how these amount have been arrived to, there is no substance to that. And the term of market value, how to determine the price, has been derived out of the apex court judgment that was based on Land Acquisition Act, because my lords, under Land Acquisition Act there was no procedure how to determine the price of the land value. So the Supreme Court has in various cases made out the factors to determine. But my lord, to overcome all those different judgment, the Right to Fair Compensation Act has come, and it has clearly prescribed the due procedure under section 26, and Kala has rightfully determined the rates in duly compliance of section 26, my lords.
So what is the rate? 150 or what? What is the rate given?
My lords, these are the escalated rate at page 143. The earlier rate in place of
153.
153 is a revised rate, my lord.
This is the revised rate made by the government?
Made by the arbitrator.
Made by the arbitrator?
Arbitrator.
And where is the earlier rate?
My lord, at page 35, my lords. The operative part is at page 37, my lords.
How did he come to this? Who is he?
My lord, how he came to this could be determined from page 36, my lords.
No, I'm not on this Kala.
All right, my lords.
I am on this...
figures arrived by the arbitrator, arbitrarily, my lords.
How has he come to this? He cannot give his own rate as he thinks.
That's the whole
I might have one rate, he might have one rate. What is wrong? He has to say what is wrong with the Kala's rate. What is wrong?
There is one more factor, my lords. My lord, may come to page 153, my lords.
Oh, yes.
Arbitrator. My lord, the petitioner before arbitrator were following only in grade B and C, whereas arbitrator has increased the grade A rates also. There was no petition.
The issue before the arbitrator was with regard to B and C only.
B and C only.
But he did A also.
Yes, my lords.
Yes. Yes, you. What to do?
May please, Your Lordship. My Lord, actually, I have submitted my power just recently, so I might require some more time.
Why?
To go for
how recent did you submit your power?
I cannot recall the exact date, my Lord.
I'll refresh your memory.
My Lord.
Yeah, I'll refresh your memory. You are for 1 to 3, 5
1 to 3, 5 to 8, my Lord.
5 to 8, na?
My Lord.
You have signed this in April.
So subsequently, my
Lord. So April.
After that, I was on medical leave, my Lord.
You are on medical leave.
It was reflected, my Lord.
And how much time do you think you need to read one file? And did you just take this case without knowing anything about the case?
No, my lord.
Just you knew, you read, you talked to your clients, you knew the case, and then you took it up, no? Or did you say that, okay, give me the case, I'll read it later, and you have not read it since April?
It's not like that.
Huh?
No, my lord, it's not like that.
It's not recent, Mr. Counsel. April is more than there's May between April and June.
True, my lord.
That is no excuse. That is a very, very, very feeble attempt to adjourn the matter. If you want, you can say frankly that I am not ready. Don't try to give you are supposed to be ready. All the lawyers who come here, they know I think the cause list is issued one day earlier. And in one night they have to read.
My lord, in that case, I think we can proceed, my lord.
No, I'll give you time if you're not
My
ready.
lord, my lord.
That's not the issue. I'll give you time, but next time when you make a submission, be fair. We have also been lawyers, we know how much time it takes to read a case. The thing is, the issue that he has raised is this. You have been given compensation at a certain rate. You are not happy with the rate. You have gone for arbitration.
True, my lord.
The arbitrator has not given any reasoning as to why the rates should be enhanced, and he has enhanced the rates. Nothing regarding the market value, nothing with regard to whether he has seen any sale deed or anything. There's no basis. He just talks about Supreme Court judgments and this judgment and that judgment and raises it. And the issue for enhancement was with regard to grade B and C land only. But he has raised grade A land also. He has gone totally beyond what his reference was. Either he's getting a share of it or what, we do not know. Why should he just raise? What is wrong? He has not said what is wrong with the Kala's assessment. He should say what is wrong with the Kala's assessment. He cannot raise just like that. A person might buy an electric wire from Aizol at maybe 100 rupees a meter. While you might get the same thing in Silchar for maybe 10 rupees a meter. So it depends how you look at things. But that does not give you a right to change things as you want. When do you want? Because it has to come to me only.
My lord.
So you cannot, because these cases are come to me only.
My lord, next week, if my lordship is available.
Monday.
My lord.
Monday. Okay, right. On the prayer of the counsel for the private respondents, list the matter on Monday. The appellant is aggrieved with the enhancement of the compensation amount payable to the private respondents for acquisition of their lands. Full stop. The stand of the appellants is that no reason has been given by the arbitrator in enhancing the rate of compensation. Full stop. There is no reference to any market value or sale deed or any other document which gives value of the neighboring lands. He has only referred to judgments of the Supreme Court without going into the specifics, without going into the actual monetary value of the lands. The arbitrator has also not made any observation or finding that the compensation amount assessed by CALA, CALA, was not correct. Full stop. Further, while the private respondents were aggrieved with the enhancement of their grade B and C land, the arbitrator has also enhanced the compensation amount payable for grade A land. First stop. Next paragraph. The land value made by Kala for Kolasib district is as follows. Page 37. Then in page 153, next will be next para. The arbitrators enhanced rate of land value is as follows. Page 153. Take this. This is the matter on Monday. So that's the basic thing. Should there be some reasons given or no reason should be given? That's the These are all arbitration matters. How come just multiplied these arbitration matters? I think
My lord, in this case, similar to yesterday's case, because of the reasons cited by my learned friend, we had approached the arbitrator. And after approaching the arbitrator issued a notice for joint verification report. And since my learned friend did not annex this joint verification report, if I may place it before this honorable court. I've also placed the joint verification report.
So you were given in your VC pass,
Yes,
you were given compensation.
Correct.
By the arbitrator.
No, by Kala?
By Kala has excluded. Kala has not given the compensation for 5 structure.
For land?
For land they have given me, but for the other 5 structures...
Not for the land, for the crops and other things that were attached to the
crops.
land.
Sorry, crops. Crops, and however, my godowns, my chokidars and other structures have been included, even though they were initially in the assessment sheet. And because...
when was the assessment sheet made?
The assessment sheet made, I cannot say the actual date, but it's in page number 60.
Made by whom?
Kala.
Assessment sheet is made by whom?
Kala, my lord.
By the official of land and revenue settlement.
Prior to the award?
Yes, my lord.
Prior to the award.
So if it's there prior to the award, then?
My lords, if may kindly come to, may review the page 65, my lords.
Page 65. Page 65 of what?
Appeal, my lords. Paper book.
Yes.
My lord, this is a reply submitted by Kala before the learned arbitrator. My lords, may come to third para. Moreover, preliminary survey for package 3 was conducted from 2/2/2021. Wrongly written, it is 1/2/2021, which is annexed as annexure number 2 onwards, where the building and assets has been marked for each particular location. Based on this, clearly show that the building assets that were built therein, annexure number 3, the absence of the building symbol within the area of Pazama land in the LA plan map clearly establish that the complainant has not built any structure at that time.
One thing, when was the, you see, the issue is not with the freezing order. Freezing order does not say anything besides the fact that no further allotment of land can be given.
Yes.
Now, when was the award out here passed? When was the date of the award? You all don't know this as a simple fact. When was the 3A notification issued?
The 3G revised estimate was issued on 12th May 2022.
Revised estimate on 22?
12th May 2022.
And the earlier one? And the pre-revised 3G?
I don't think it is annexed in this.
Look, you all don't have anything in your fingertips.
My lords, that is at page 42, my lords.
I'm not asking which page it is. I'm asking you the date.
My lord, that's 12th May 2022.
That is the revised award. That's what he's saying. If that is the revised award, is there a pre-revised award? It has to be.
Yes, my lords. My lords, we have only enclosed the final 3G award, which is revised one, my lords. My lords, the whole question is whether on the land which is through VC pass holder for agriculture purpose, can a 5 structure be constructed on that land and thereupon a compensation can be claimed for that?
I don't know. Could be done for agricultural purposes.
My lords, it's a go down, 5 go down, they're
of course,
claiming, my lords.
But agriculture.
My lord, on the earlier occasions, the records of the arbitration proceedings and the records of the Sessions Court have been called. The records of the Sessions Court had reached this Honorable Court, and the arbitrator's report has not been received. Now, the reason why these records have been called was because my learned friends, their bone contention in this case is that there was patent illegality and there was no evidence. And because of that very reason, these 2 records were called. And with regard to that aspect, my lord, my learned friends, on the very first occasion, they had relied on the Sangyong's judgment, which your lordship had also already dictated in the earlier occasion. With regards to that aspect, there is a very recent judgment by the Honorable Supreme Court, which, if I would rely upon the same, my lord.
Yes, yes.
In this judgment, my lord, the relevant paras, the points for consideration starts from para number 26, page number 13. This is 2025 INSC 1457.
Yes.
The points for consideration starts from para number 26. If I may read, my lord. Having heard the learned senior counsels at length on behalf of both the parties and after examining the material on the record, we are of the considered opinion that the core issue that arises for our consideration is whether interference with the arbitral award by the High Court under Section 37 of the Arbitration and Conciliation Act 1996 on the ground of patent illegality is sustainable when on this, sorry my lord, when once the award has been affirmed under Section 34 of the Arbitration and Conciliation Act 1996. Discussion or our analysis. If I may read down all the way down from para number 28. The bare perusal of Section 34 mandates that a narrow lens of supervisory jurisdiction to set aside the arbitral award strictly on the grounds and parameters enumerated in subsection 2 and 3 thereof. The interference is permitted where the award is found to be in contravention to public policy of India, is contrary to the fundamental policy of Indian law, or offends the most basic notions of morality and justice. Hence, a plain and purposive reading of the Section 34 makes it abundantly clear that the scope of interference by a judicial body is extremely narrow. It is a settled proposition of law, as has been constantly observed by this court, and we reiterate the courts exercising jurisdiction under Section 34 do not sit in appeal over the arbitral award. Hence, they are not expected to examine the legality, reasonableness, or correctness of findings on facts or law unless they come under any grounds mandated in the said provision. I will not read the entire thing, but I will read the other relevant portions, my lord, where Sangyon's case was discussed.
But what about, look, in ONGC limited saw pipes, this court held that award can be set aside under Section 34 on the following grounds, Sir D.
Yes.
If it is patently illegal.
Correct. Now we will have to consider whether the arbitral award is patently illegal. Now, what should be deemed to be a patently illegal award? Perhaps if the arbitrator makes the award out of thin air, like not relying on any documents at all, that can be deemed to be...
So what his case is that a land covered by a VC garden pass is an invalid pass, which means that whoever claims to be the owner of a land on the basis of a VC garden pass is not the owner of the land. because he is not the legal owner.
But my ownership has not been disputed anywhere.
No, it's not a question of your ownership. It's the question of your past. You see, just because, supposing you have been given a BA pass degree certificate.
Yes.
But that BA pass degree certificate is issued by a by a university which is not recognized by the UGC. So that doesn't make you a BA pass, because it is issued by a non-registered, non-recognized university or college. Just because some people treat you to be a BA pass does not make you to be a BA pass. Similarly here, what he is trying to say is that when the land has been issued to you on the basis of a void document, invalid or void document, you cannot be said to be the landowner. Similarly, supposing I am being given a class 10 pass certificate in Aizawl by some board of secondary education in Bangladesh, say, that Bangladesh authority does not have any right to give me a pass, a certificate in respect of my schooling here in Mizoram. So that document is void. That document does not prove that I am a class 10 pass. Similarly, what he is trying to say is, your VC pass is a void document. It is an invalid document. So you cannot be said to be a landowner. That's what he's trying to say. So that is what he's trying. So if you are not the landowner, you have been given compensation for the crops, maybe because you are using the land for whatever reason, maybe humanitarian reason, but you have not been given the compensation as a valid landowner. So if you have constructed some plot, some building in some land which is not yours, then they don't need to pay anything to you. That's what he's trying to say. Now you counter that. That's
yes. Regarding that aspect, my lord, it is not in dispute. There is no utter of dispute regarding the validity of my passes or the ownership of my land or my ownership over the structures that are there on my land. The point of contention in this case is whether these structures exist or not. And these grounds were never challenged before the arbitrator. And these grounds which my learned friend just pointed out now regarding the validity of my VC passes, whether I am entitled to get compensation because my land is a VC pass, that ground was never taken in the Section 34 appeal. Now they have raised it for the first time. Even in their memo of appeal, they have never uttered that kind of contention. The issue which they raise primarily are that one, there is a patent illegality because there is no evidence taken at all. And two, is that these structures, according to the documents of the DC Kala, they have not been existed prior to the freezing order. That is their main ground of contention. And now regarding the VC pass and issue, they have raised it for the first time in this court. And I would like to continue my submission regarding the citation I have raised, my lord, because it's very relevant. This Sangyon's case, relied by my learned friend, has been discussed in para number 34, page number 20, if I may read, my lord.
Please, where are you going back? Carry on reading, para 29.
Para 20.
9.
Oh, my lord. Para 29, when it comes to Section 37 of the Arbitration and Conciliation Act, it provides for a limited appellate remedy against an order either setting aside or refusing to set aside an arbitral award passed by civil court in exercise of its power under Section 34. This court in MMTC Limited versus Vedanta Limited at paragraph number 14 observed that interference with an order made under section 37 cannot travel beyond the restrictions laid down in section 34. Further, in Konkan Railway Corporation Limited versus so-and-so, this court at paragraph 18 observed that the scope of appellate scrutiny under section 37 is necessarily coextensive with the parameters mandated under section 34 of the Act, and hence the said provision does not enlarge the jurisdiction of the appellate court. Even this court has observed in MS Hindustan Construction Company Limited versus so-and-so, wherein one of us was part of the bench at paragraph 26, that the standard of scrutiny of an arbitral award is very narrow and it is not the judicial review of an award. Further, in paragraph 27, it was observed that awards which contains reasons, especially when they interpret contractual terms, ought not to be interfered with lightly. This court has observed in Larsen Air Conditioning and Refrigeration Company versus Union of India and others at paragraph 15 that the scope of interference in exercise of appellate power under section 37 is even narrower to review the findings of the awards if it has been upheld or substantially upheld under section 34. Hence, it is very well settled that arbitral awards are not liable to be set aside merely on the grounds of erroneous in law or alleged misappreciation of evidence, and there is a threshold that the party seeking for the award to be set aside has to justify before the judicial body could enter into the realm of exercising its power under section 34 and 37. It is also apt and appropriate to note that reassessment or reappreciation of evidence lies outside the contours of judicial review under sections 34 and 37. This court in Punjab State Civil Supplies so-and-so at paragraph number 12 observed that even when the arbitral awards may appear to be unreasonable and non-speaking, that by itself would not warrant the courts to interfere with the award unless that unreasonableness has harmed the public policy or fundamental policy of Indian law. It might be a possibility that on reappreciation of evidence, the courts may take another view, which may be even more plausible, but that also does not leave scope for the courts to reappraise the evidence and arrive at a different view. This part is very important, my lord. This court in Batli Boy Environmental Engineers Limited versus Hindustan Petroleum Corporation Limited and another held that the arbitrator is generally considered as ultimate master of quality and quantity of evidence. Even an award which is based on little or no evidence would not be held to be invalid. This part, if Your Lordship may kindly note this section.
Correct.
Even an award which is based on little or no evidence would not be held to be invalid on this score. At times, the decisions are taken by the arbitrator acting on equity, and such decisions can be just and fair. Therefore, awards should not be overridden under section 34 and 37 of the Arbitration and Conciliation Act on the ground that the approach of the arbitrator was arbitrary and capricious. Hence, in light of the aforesaid discussion, we will deal with the submissions made by the learned counsels, senior counsels on behalf of the parties. But there is yet another aspect that warrants our attention before delving into the analysis of submission, and that is the setting aside of the impugned order by the High Court by placing reliance on the ground of patent illegality. Therefore, it becomes imperative to understand the true import of the said term before we move further. Prior to the 2025 amendment, the ground of patent illegality emerged as a result of judicial interpretation in ONGC Limited Supra, while interpreting public policy mandated under section 34, subsection B, subsection 2 of Arbitration Conciliation Act, wherein this court for the first time read patent illegality as a sub-ground to set aside the award. On the broader purport of public policy in paragraph number 22 of the decision, this court observed, there is a case where the validity of award is challenged, there is no necessity of giving a narrower meaning to the term public policy of India. On the contrary, wider meaning is required to be given so that the patent illegality award passed by the arbitral tribunal could be set aside. This court went on to illustrate what would constitute patent illegality at paragraph 22, and we extract the same for easy reference. I will not read all this, my lord. What they are saying are more or less the same. I would like to take you to the most relevant portions, my lord, which I would like to substantiate upon, and where the Sangyon's case was discussed, my lord. If I may read from para number 33, page number 19.
Yes.
In 2015, by way of the Arbitration and Conciliation Amendment Act, a new subsection 2A to Section 34 of Arbitration and Conciliation Act was inserted, which, in addition to statutorily recognizing the patent illegality ground for setting aside a domestic arbitral award, made it an independent and distinct ground from public policy under Section 34. The proviso to the newly inserted clause further provided that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. The legislative intent behind insertion of this proviso was to avoid excessive intervention to arbitral award by the courts under the ground of patent illegality. However, the amendment clarified that an erroneous application of the law or reappreciation of evidence does not fall under patent illegality. Hence, the courts are not to treat every factual error or every divergent interpretation as an illegality. The illegality must be a kind that strikes at the heart of the award's validity. For instance, if an arbitrator ignores a binding precedent or a clear prohibition in the contract, that may be patent illegality. Likewise, a finding based on no evidence at all can be said to be perverse and thus patently illegal.
So, based on no evidence.
That is their ground, but...
No, it says here. You just read it. Likewise, a finding based on no evidence at all.
Now, what is deemed to be no evidence?
Okay.
It was described in para 35. Likewise, a finding based on no evidence at all can be said to be perverse and thus patently illegal. But where there is some evidence and a reasonably plausible inference has been drawn by the arbitrators, the courts should ordinarily refrain themselves from supplanting the views arrived by the arbitrator, as that would be the true import of the legislative intent inherent in the Amendment Act. Para 34. Thereafter, this part is very important, para 34 and 35, my lord. Thereafter, this court elucidated the meaning of the expression patent illegality in Sangyong Engineering and Construction Co. Limited versus National NHAI, while taking into consideration the Amendment Act of 2015, and held it as a glaring evident illegality that goes to the root of the award. This includes A, an award deciding matters outside the scope of the arbitration beyond the contract or submission. B, an award contradicting the substantive law of India or the Arbitration Act itself. C, an award against the terms of the contract, and an award so unreasoned or irrational that it manifests an error on its face. Considering the aforesaid precedents, in our considered view, the said terminology of patent illegality indicates that more than one scenario, such as the findings of the arbitrator, must shock the judicial conscience, or the arbitrator took into account matters he shouldn't have. This part is very important, my lord. It should shock the judicial conscience of the court.
It shocks me slightly. when you see, the thing is that so if I can be given land, the LSE land has to be given. LSE is the way to give land, periodic pata is the way to give land. Then if a person who is not the government gives me LSE, then won't it shock you? Or you will say, no, it's okay. Anyway, carry on.
Must shock the judicial conscience, or the arbitrator took into account matters he shouldn't have, or he must have failed to take into account vital matters, leading to an unjust result, or the decision is so irrational.
Or he must have failed to take into account vital matters.
Yes, vital matters leading to an unjust result, or the decision is so irrational that no fair or sensible person would have arrived at it given the same facts. And this part is again very important, starting from a classic example.
No, you see, when you read it,
yes,
it becomes wider and wider.
Yes, my lord.
Now, para 35 not only talks about shocking and whatnot, that leaving that aside, or that he took into account matters that he shouldn't have, but he also says, or he failed to take into account vital matters. So, whether he failed to take into account vital matters, we'll have to see.
My lord. No,
according to you, it's not vital. According to me, I don't know, let me see if it's vital or not.
Yes.
According to him, it is vital. According to you, it is not vital.
Yes.
I will take a decision on that.
Yes. Yes.
So now the thing is,
No, my lord.
what is vital, what is not vital is the question in issue.
If I may finish reading this,
Yes,
my lord,
yes.
because it's so important. A classic example for the same is when an award is based on no evidence.
Correct.
Now, no evidence is described here. No evidence, that is, arbitrators cannot conjure figures or facts out of thin air to arrive at findings, full stop. If a crucial finding is unsupported by any evidence or is a result of ignoring vital evidence that was placed before the arbitrator, it must be a ground that warrants interference. However, the said parameter must be applied with caution by keeping in mind that no evidence means truly no relevant evidence, not scant or weak evidence. If there is some evidence, even a single witness testimony or a set of documents, it uses the term witness testimony or a set of documents, my lord, on which the arbitrator could rely upon or has relied upon to arrive at his conclusions, the court cannot regard the conclusion drawn by the arbitrator as patently illegal merely because that evidence has less probative value. This thin line is to crossed only when the arbitral tribunal's conclusion cannot be reconciled with any permissible view of the evidence. Now, my lord, what I am trying to raise before this honorable court is that the arbitrator, number one, did not make her decision out of thin air. It was based on documents submitted by us. It was based on the joint spot verification report, which I have just submitted to the.
No, you see, the issue is this. There is no denial of the fact that those buildings are yours.
Yes.
There is no denial. The issue is, was it there at the relevant point of time? That is the issue. That is what we are trying to find out. That goes to the core of the case. That is, at the time when the award was made or a Section 3A notification was issued, was that building there? That's all.
It was there, my lord.
We will see. You saying it was there, that is neither here nor there. We have to see the evidence. Not you are saying so, there is not evidence.
Yes.
You see, because the Kala had also undertaken an assessment. During that time it was not there. That's why they did not give you. So that is where we will have to see. So you see, when you say evidence, it's not what comes out of your mouth that is evidence. You have got to show it from the documents.
Yes, yes.
So both of you will have to show it from the documents. So that is the thing.
Yes, my lord. Because of the very reason which they say our land was not there, we had approached the arbitrator. And after we approached the arbitrator took the matter into consideration.
Let me see your appeal. Wait, before that, Section 3 notification was issued here also?
Yes, my lord.
Section 3 issued when? You all are so unprepared, my God.
My lords, I
this
only
should be in your fingertips, all these
I
dates.
only have the date of freezing order, my lords, not 3A notification.
Land freezing order is dated 1/6/2020.
20, my lords.
2021, sorry, my lord.
And an award is dated 12/5/22.
Yes, my lords.
And 3A notification issued when?
21/5/2021.
21/5/21. After the 3G award, how can it be? At 22. Okay, after the freezing order.
My lords,
My
lords, what is the repercussion of the freezing order? It is issued by the state of Mizoram, by the Department of Land and Revenue.
Correct.
My lord, once the freezing order is issued, they say no mutation will be allowed. Further, my lord has an important question that how come it debars the betterment of land? So, my lords, whenever
it does not debar. Freezing order does not debar the betterment.
My lords, I want to submit something, my lords. It is that, my lords, whenever we have a land, now whenever we construct a building, we do not arbitrarily construct a building. We need to take certain permission of the authorities of the state of Mizoram.
No. Not in those villages and outside. No. Only in Aizawl. Only where there is a municipality. Only in Aizawl and in Lungli. In Lungli also because they came into existence only a few years back.
So my lord,
there is no need of permission.
So, my lord, that comes around that we have two documents on record. One is submitted by Kala, which is at page 69, which is a CAD drawing, which draws the land of the petitioner or the respondent.
Dated. What is the date?
My lord, that's 3/5/21.
Okay.
My lord, page 69, on the top half, there is a marked P. Pazama land. My lord, it says the
Pazona land.
land. It says VC pass number which belongs to the respondent.
Yes.
My lord, this is the document which has been provided by Kala to substantiate that on this date, there was no building existing on the land.
From where do you get the date?
My lords, date is at page 69, my lords.
Where?
At the bottom corner, my lord. At the bottom corner.
Which side?
My lords, the date is at page 65, my lords. 65 is the reply towards which this document has been annexed.
Detail on
65, my lords. 65 tells the date, my lords.
You see, page 65 is of 2024.
My lords,
this
map has been
was made prior to 2024. So which date?
So, my lords, the Kala has specified the date here on this covering letter, my lords.
Where?
3/5/21, my lords, third para, middle of the line. Based on this, transient consultancy prepared
Which page?
Page 65, my lords, page 65.
It is page 65, the letter to Miss Martini.
Yes, that's a covering letter in which the document is annexed, which we have referred
Correct. So what does it say?
Third para, second line, based on this, transient consultancy prepared LA plan map on 3/5/2021 using AutoCAD software, which clearly showed...
Where do you get that based on this? Which paragraph?
Page number 65, third para.
How does third para start? What is the first one?
Moreover, preliminary survey for the package was conducted on 2/2/2021, Annex 2 onwards, where the building and asset has been marked for each of the particular location. Based on this, transient consultancy prepared LA plan map on 3/5/2021 using the AutoCAD software, which clearly show building and assets which were built thereon, which clearly shows that there were no building within the land of the respondent number 1.
My lord, the findings written here, in which my learned friend had just read out, these are the reasons why we were aggrieved and we approached the arbitrator. And when after approaching the arbitrator, all of us, including the NHIDCL officials, we went to the spot and we verified the place. And the person who made the joint verification report is the subdivision, is the SDC, and the SDC said that these buildings were all there.
My lords, let's see how it has been perused through the award, my lords. What is the finding of the award, my lords, which is at page 71.
Yes.
My lords, para number 3.
Yes.
Further, to have a clear picture of the case and for the fair and justification application of mine, an interim order was issued on 27/3/24. Please may note this also, my lords. That is 4 years after, for a joint spot verification with all the concerned party. Pursuant to the interim order, joint verification was carried out by Kala Kolaseb on 3 May 2024. As per the report, the following structure was standing on their same location before the land freezing notification. My lords, how come it being derived
as per the report, the following structure was standing at the same before the freezing notification?
How this conclusion was derived, my lords, after 4 years?
I can clarify.
And my lords may come to para 5.
We'll give you time, Mr. Counsel. Don't interject.
Para 5 is more shocking.
Just a minute. 1 minute. Joint spot carried out by Kala on 3/5/24?
3/5/24, my lords.
Kala has also gone for inspection.
My lords, para 5 is more shocking.
Yes.
Owing to the above, and as the petitioner is satisfied with the joint inspection and feels that hearing is not found necessary any further, Kala Kolasiv will make the assessment of the above structure. So, my lords, an inspection is done after 4 years, a report is submitted, an arbitrator decide no further hearing, and the petitioner decide no further hearing is required, so he decides the awards. And he has overruled the submission of Kala with a CAD drawing, which certifies that the building did not exist. Furthermore, a very important factor that the land of the respondent number 1 is derived out of VC pass holder. And VC pass holder has no permission to construct a structure because it is for the agriculture purpose. Now, despite that, he claims that 5 structures are there, and the arbitrator, learned arbitrator, has included the 5 structure.
What structures are there? RCC?
Yes, my lords.
No,
My lords,
godowns,
godowns,
Chokidar house,
And
certain structures. The structures, they are listed out in
my lord, at page 62,
number
which says
62,
go down,
yes,
go
the
down
initial assessment.
RCC building, Assam type, go down RCC building and Assam type. Page 65, my lords.
the first survey could be wrong also.
GAD drawing, my lords.
Yes. How do you know that that survey was correct?
My lords, that's the submission of Kala. They have relied upon a document, and my lords, particularly this land derives out of VC pass for agriculture.
Let us see your letter for having the matter sent for arbitration. Where is that?
Yes, my lord. In the appeal memo, this letter was written by the respondent private person himself, by hand.
Page 58, my lords.
Page 58. The English translation is in page number 58A. This is in the Mizo vernacular. Page 58B is the English translation. If I may read, my lord.
Yes.
To the arbitrator, land acquisition, Mizoram, basement 2, room B, 094, so and so. Request for assessment of go down in 80 building that has been missed out in the previous assessment. Madam, it is brought to your notice that 4-lane construction will affect our land bearing VC pass number 288 of 2010, and we accepted the crops value already assessed. At the same time, the buildings and 80 were also assessed during the said assessment, and the area was also highlighted in RTI response. However, it was noted that the value of the mentioned structures seemed to be included in the property evaluation. As such, I kindly requested to do the reassessment of those structures within my land. This may be read along with the Mizo translation.
Can go down Chokidar in 80 and what is 80?
Assam type house.
Chokidar in Assam type. Ek in le in te. There are only 4 buildings here. How come you have 5?
My lords, why I say 5?
Yes, sir. No.
They came, okay.
Where is the English translation of this page 58A? It is not here. Page 58.
Page 58.
This is your letter, no?
True type is 58B, my lords.
Huh?
True type is 58B.
58B.
Next page, my lords. True type.
I don't have 58B.
The original is page 58, Annexure C, written by the respondent, private respondent himself. And
Yes,
58A
out here there is only 4 buildings. Ama erochu heram chunga can go down. Chokidar in 80, what is 80?
Assam
type. Chokidar in 80.
Ek in,
the
inte.
So there are only 4. There are no 5 buildings.
Go down 1, Chokidar into 80,
No, 80 is Chokidar-in is the Chokidar-in is a subtype of.
There are more than one godowns. Perhaps, my lord, since this was written by a layman,
Layman will know how much he has got, how many houses he got. What do you mean? It has to be written by a lawyer?
no, my lord, I think the actual proper list, they are there in the initial assessment sheet, and those that are there in the joint spot verification report, those are the true list of lands. This was just a mere letter written by a layman himself. Perhaps.
So, no, what do you mean, layman? Supposing you mean a villager who does not know how many houses he has got, or how many pigs he has got, or how many chickens he has got. They know more than you. You may know the law, but they know the property. Everyone knows what you have got. He's written it here. How can you say, can that be an excuse? He's a layman. He knows. He says, go down.
Go down is 1, Chokidar-in is 2,
Yeah.
Assam type is 3.
No. Sorry. In-te means what? Then in-te is what? Assam type is. No. Chokidar is. Chokidar in 80, it says. Then comma. Then ek in le. In-te.
1, 2, 3, 4, 5.
He doesn't live here, Mr. Counsel. He doesn't live here in this place.
They use this. He used this place to store certain items.
Correct, and that's why he has got his inte. This is a garden. This is supposed to be a garden. He is not residing in his garden, is he? Is he residing in his garden?
No, my lord.
He is not residing. He is residing in Chimluang, Kolasip district. And this land is in Vairengte. What are you trying to be
my lord,
too smart?
The letter which is written down here.
Please be fair. Please be fair to the court.
Yes, my lord.
Don't try to be over smart at times. You know, it takes us. It gives a wrong impression.
My lord. My lord, I think this letter which is written by the private respondent here, perhaps I think it should be taken as a grain of salt, because the actual...
No, you cannot. If we take this as a grain of salt, then everything you say is going to become a grain of salt. You see, if you say that this document...
No, not this document, the inaccuracies, my lord.
The accuracy?
The inaccuracies.
The inaccuracy. Where have you said that this is inaccurate?
No, my lord, I think your lordship has pointed out the inaccuracies of the number of the buildings, but I think we should look into the joint spot verification report and the initial assessments.
No. This is from the horse's mouth. This is from the horse's mouth. This is from the horse's mouth. Supposing you say you have got 10 rupees, and I say no, you have got 20,000 crores. You should believe me. You think that C or D or 20 other person should believe me or believe you about how much you have? You have to be understand. You have to be reasonable. Otherwise, what's the point of giving evidence? What's the point of filing affidavits? Anyway, so this is there. So they go down Chokidar, Assam type, a small house. Let us see the arbitrator's award.
Yes, ma'am.
Let me clarify that aspect, my lord, a bit, because I think I can clarify what seems to be an inaccuracy. If we look into page number 62, my lord, 62 of the appeal memo.
Just a minute. Just let me see the award.
Arbitrator's award is at page 71, my lord.
Yes. Just let me see. Yes.
The operative part is at para 5, page
Yes.
72. After the joint inspection was done, which is
Yes.
4 years after, my lords, and based upon that the petitioner is satisfied.
Page 70?
72, my lords, operative para 5. This is after what joint inspection has been done. Owing to the above, and as the petitioner is satisfied with the joint inspection and feel that hearing is not found necessary.
Hearing is not found necessary.
Because he is satisfied with the joint inspection that, yeah, 5 buildings are there today. So he says to the arbitrator, hearing is not necessary.
There is a patent
Yes,
irregularity here.
My lord?
No hearing.
Yes.
No hearing allowed.
My lord, to adjudicate upon that factor, we will have to look into the Arbitration and Conciliation Act.
No. Sorry. I just have got to look at what the arbitrator has to say, not the act. It
Because,
says here,
because the Act allows it, my lord.
allows what? That no need of hearing.
The Act allows the arbitrator to conduct the manner which is deemed appropriate.
Oh, and what about principles of natural justice?
Principles of natural justice will not lie here because...
Oh, sorry. Okay. Heard.
No, my lord.
I know enough. I've heard you.
My lord,
I've
because
heard.
the joint...
This is impossible.
No, my lord,
you tell me that you go for arbitration, you go
Yes.
to a court, you go to tribunals, you go to so many things, and you
Yes.
don't have to have hearing.
No, what I'm trying
My
to
God.
impress
That
upon...
if you are going in that line, there's nothing.
No,
else.
my lord, what I'm trying to impress upon the court is that they were present in the joint verification report. Perhaps that is why the
Heard.
reason the arbitrator says that no hearing is found necessary. Only that much I am
That is
arguing.
where it's wrong. Hearing is necessary in every court, in every tribunal, in every arbitration. Hearing is necessary. Without hearing, there's nothing. Supposing this court says that hearing is not necessary, I've got inherent powers. Can it be done? What does the Supreme Court say? Every decision has to have some reasons. And to have that reasons, you have got to have a hearing. Otherwise, how will you know what the other man is thinking? Well, how do I know what you are thinking or he is thinking? Supposing I am the arbitrator, I have to hear both of you. We'll remand it back to the arbitrator. Let him decide afresh.
My lord, perhaps since the arbitrator are not trained judicial officers, perhaps
No. He might not be a judicial officer. Ignorance of law is no excuse.
And
that thing. Okay, right.
one aspect, my lord, which I need to,
Heard.
which I must clarify, my lord.
Hearing concluded, judgment reserved.
Perhaps, my lord, since judgment is reserved, one thing I must clarify regarding the letter.
Finish, next.
Item 9.
Please don't make submissions like no hearing is required. Everywhere in all your writ petitions, in all your cases in the courts, I've never heard of a decision being allowed to stand where no hearing is allowed. They have to have a hearing. Every time you come in a writ petition, you say no notice was issued. That means what? Alderi alteram partem. No person should be condemned unheard. You have to hear them.
Perhaps the arbitrator was under the impression that since
That
there
is why
the
I am
report-
sending it back. You all decide the issue afresh with him. Let them have a hearing.
My
Let
lord.
him have a hearing. That's all.
My lord.
There have to be a hearing. Without a hearing, how can it be done? Otherwise, you are most welcome to go to the Supreme Court. There is a patent illegality according to me. Right.
My lords,
Next. What is this matter?
my lords, this matter pertains again to the two issue of enhancement of the rate. It is similarly that Kala award has not been challenged and the market value has been determined as per the...
What about this? What did you say? Out here?
My lord, there,
Item 9?
Item 9, there are two issues. One is enhancement of the rate.
Enhancement of rate.
That is, has been done similarly to the last cases that we have discussed, my lords, that it has been enhanced without challenging the Kala order, which is determined as per section 26. Further, the market value term has been determined as per the apex court order, which were pertaining to Land Acquisition Act, and further been enhanced. Similarly, my lord, in this also, the petitioner land belongs to one of the three grade B, one of the category for non-residential, but has been enhanced for all the categories in grade B.
This is out here, all the land was grade B.
Grade B, yes, my lord.
Grade B, but grade B and C were enhanced.
My lord, in grade B also there are three categories: residential, non-residential, and bypass area. Now let's may come to page 2 to 5.
No, I'll tell you what I'll do. I'll first pass this order.
All right.
And out here in item 9, it is only enhancement.
No, my lords, there's a second issue also.
What?
There were 5 structures as claimed by the respondent. 3 has been included by the Kala, and learned arbitrator thereafter included the 2. That is also been again done on the basis of a joint inspection.
Let us see the arbitrator's award again.
Yes, please.
Page 216.
216.
Okay, out here he seems to have heard.
Yes, madam.
Huh?
Yes, madam. Hearing was done.
Hearing was done.
Yes, madam.
In the other one, there was no hearing.
Yes, madam. My lord, with respect to enhancement of rate, my lord may come to page 2 to 4.
Huh? 2?
2 to 4, my lords.
Yes.
My lords, I'll start from the beginning of this page. As regard to the adoption of the crucial market value of the land by the collector, legal requirement have already been highlighted. That means all the Supreme Court judgments, my lord, that pertain to Land Acquisition Act. The land value of the petitioner is fixed at rupees 106,8564, which is wrong to say, my lords, because respondent lands belongs to only 85 category. In the village of Verengte, Bilkhatri, Konpui and Bolpui. Considering the fact that the commercialization and local development activity and increased human settlement have pushed the market value of land in the higher ridge, especially land in commercial area, would command higher increase in their value. In addition, there are some stretch of land of non-settlement area, and market value of such land would never have those high-end commercial areas. Having acknowledged these aspects, Kala broadly came to the conclusion that the highest commercial area would be fixed at 106 square feet, and whereas the market value of non-settlement area can be broadly fixed at 64 square feet. Kala further made micro division of settlement area and non-settlement into grades, and their respective potential value, market value has been worked out. Next para is very important, my lords. These are necessarily reflected in this arbitral award, and the reason being the stupendous exercise done by Kala. It appreciates the work done by Kala, my lords, with the earnest intention to identify the most appropriate rate or value in determining the market price of the land in and around Kolasip. It appreciates, my lord, what the Kala has done. My lord, may come to para 10.6, my lords. The next argument of the AR means the representative of the petitioner, my lords, is about the method used by Kala in working out the average rate of land value. As highlighted, the learned ARs severally criticized the method deployed by Kala in working out the market value using the registered sale deed. For refreshing the memory, the AR pleaded that the correct method is provided in explanation number 2 of section 26, which has been followed by Kala, my lord. which clearly provide that in order to arrive at the average sale price, 1/2 of the total sale deed in which the highest sale price is mentioned is to be taken into account. That is how Kala derived at the rate, my lord. And my lord, the next para is very suspicious because it does not form part of any of the section. Collector is required to keep in mind the following factor. I don't know, my lord, where does it come out? Existing geological situation of the land, existing use of land, already available advantage like proximity to national highway or state highway or road or developed area. My lord, next page, para 10.7.
Who is this arbitrator? Lalrin Zwali.
Lalrin Zwali. Para 10.7, how the learned arbitrator has determined the rate. The term market value was defined to means the price that a willing purchaser would pay to a willing seller for a property having due regard to its existing condition with all its existing advantage and its potential possibility when laid out in its most advantageous manner, excluding any advantage due to carrying out to the scheme for the purpose for which the property was compulsorily acquired.
Where are you reading?
Matlab, para 10.7, page 2 to 5.
10.7?
10.7 para, 2 to 5 page. The term market value was defined to mean...
She is only talking about the law. There is nothing with regard to the issue at hand.
Yes, my lords. And this may be the outcome of some Supreme Court judgment, but that was pertaining to Land Acquisition Act when there was no procedure how to determine.
That is not the issue. The law is not the issue. The law is clear. You have to know how the market rate of the new market rate enhancement has been made.
Okay, my lord, that's at para 10.9, my lords. Having considered all this critical assessment using the provision of the relevant act, analysis of the judicial pronouncement elaborately discussed, and in particular the most pragmatic proposition coming from the apex court in arriving at a price agreed upon between a willing purchaser and a willing seller in an arm's length deal, and the price which it would fetch in an open market would be the ultimate clincher, and they are the golden thumb rule, avoiding the section 26 of the Right to Fair Compensation Act, my lords. The market value of the land that would be reasonably suitable for the area is indicated below. Kala is to adopt these rates in the relevant cases. My lords, the respondent number 1 falls into non-residential area but adjacent to national highway. But the other category in grade B has also been enhanced.
They are in grade B?
They are in grade B. Grade B has 3 categories: residential, non-residential, non-settlement.
Where do you get that? And what about the structures?
My lords, the structure is, my lord, page 220. My lord, it starts from page 219, last line. 219, last line, my lord, para 6. As requested by the AR, interim order was issued accordingly on 4/12/2023, my lords. The next para, my lord, para 7.
Anyway, we'll take this up on tomorrow.
My lord, one thing I would like to request, since your lordship is sending back item number 8 to the arbitrator, perhaps your lordship can fix a timeline to dispose of the matter, because this in a way prejudices us, because it will be pending there in the arbitrator for a long time. We don't know.
You see, the problem is giving a timeline also sometimes causes a problem to the arbitrator. So we used to give timeline, but then we got there were some observations made that maybe it's not the best thing to give a timeline to the arbitrators, or even to the authorities sometimes. This is what some observations have been made in some decisions.
My lord, perhaps at least a suggestion may be made which would be reasonable for the arbitrator to dispose of the
Yes,
case.
yes, that we can make, that we can do. Achha, with regard to the matter that I am sending back, after that, no hearing allowed, and the assessment was to be made by the Kala, and Kala made the assessment. That's all. After that, there was no order.
Nothing.
Nothing. That was the end. That was the last.
end. That no hearing is required.
That's all.
That's all.
And Lordship, I would like to, perhaps I was making having a slip of a tongue regarding saying that principles of natural justice is not required, which I would like to clarify that what I was trying to say at that moment was that perhaps in this case, principles of natural justice might not be deemed to be the issue by the arbitrator because there was a report. That was what I was trying to impress upon.
You see, what does the Supreme Court say? Not only does justice have to be done,
yes,
it has to appear to be done.
Correct.
So that appearance is not there.
Correct.
That appearance has to be done.
Lordship
Because
is
now
right.
all the issues now he is bringing up, he could have raised it there.
Yes.
Then we could have seen the arbitrator's award and seen what issues were decided, how he decided. But there's nothing for us to decide.
Lordship is right.
So we'll send it back. We'll give some observations here and there.
Yes.
And that is at page 70. No, you said that earlier matter. Because that decision will take some time.
It runs from page 71.
Page 71 of the award, my lords.
Page 71.
Para 5.
Para 5, no?
Yes.
This shouldn't have been done.
My lord, if I may make only one small suggestion, that when remanding the matter back to the arbitrator, the matter should start from the day of hearing or something
No.
similar.
Let it decide. We cannot. This
Lord.
is not a court. Arbitrator is not a court. It's under a statute.
Yes.
Separate statute. We cannot give such directions. Let it decide.
My lord.
Yes. Next. This is the matter tomorrow, huh?
Item 10.
Tomorrow, not tomorrow. Tomorrow, I think I've got some meeting. This is the matter. This is the matter, huh?
Your Lordship, if I may, I will be filing my vakarat on behalf of the Kala. And similar matters are listed on Monday. So
No, it will be too many to decide because they are all different. I don't know. But then your arbitrator, I do not think she has gone into the issue. She's only talked about the law. Everyone can put in a few copy-paste for the Supreme Court judgment. That is not the issue.
We will try to substantiate, my lord, as to how the arbitrator's order is not illegal.
No.
And
It's not the issue of illegality. The issue is whether she has gone into the issue at all. The issue of enhancement has to be based on some document. How do you enhance? How can you say that this pen should cost 20 rupees and not 10? How do you say that?
Those documents, my lord,
You cannot bring the Supreme Court judgments and say because of the Supreme Court judgment this. Because Supreme Court is only laying down the law. It doesn't give the parameters as to how the market value of a land has to be calculated or made. That aspect of the matter has not been touched. That is the patent. That goes to the core of the issue. That is the very basis. You are wanting enhancement. So the very basis of what you want is more money. That is the enhancement. So how do you enhance the compensation amount? That has to be decided. You look into it.
Yes.
We'll see. Maybe okay. This matter we can do it maybe whether it's Monday. Monday we fix some item. No, we didn't.
In this specific item, my lord, records were called the arbitrator.
This one.
Yes, and only the records of the the arbitration appeal have reached the registry. In
It's
this-
okay, only the arbitrator's award is necessary. The arbitrator's award, the civil court's records are not necessary. Civil
No, my
court's
lord,
records
we will have to look into the records what is there before the arbitrator.
I will look if it's there.
Yes. So perhaps your lordship can pass a direction that the records of the arbitrator.
No, we'll see. We'll hear you first. List the matter. Okay, list the matter tomorrow. We'll do it tomorrow. Then the next.
Item 10.
What about this?
May I please, Your Lordship. Your Lordship, this is an appeal under Section 37(1)(a) of Arbitration and Conciliation.
Why have you challenged the award?
Your Lordship, this is the civil court. The
Huh?
civil court refused to set aside the arbitral award.
So, it can do that.
Yes, Your Lordship, this is, the landowners is a VC pass.
So, VC
that's
pass?
why. That's why.
So, VC pass can be given compensation also?
Your Lordship, the petitioners claim a land value compensation, the market value of land value.
So?
So, the arbitration denied it. The arbitrator denied it, and it was also not refused to set aside the civil court. Your Lordship.
You call a senior. No, just tell me one thing.
Yes.
Who went to the arbitrator?
Your Lordship, the petitioners.
You?
Yes, Your Lordship.
You are not the petitioner, Mr. Counsel. This is an appeal.
Yes, Your Lordship.
So you are the appellant.
Yes, appellant.
The appellant went for arbitration.
Yes, Your Lordship.
The arbitration petition was dismissed.
Yes, Your Lordship.
And you went before the civil court.
Yes, Your Lordship.
Civil court dismissed.
Yes.
So what is wrong?
Your Lordship, because there is, may I take Your Lordship through para 21 of the arbitral award. No, the judgment and order, Your Lordship.
Of?
After index.
Page, okay. Page? Para?
12.
Para.
12 of para 21, Your
Okay.
Lordship. In my considered view, non-payment of market value of land in respect of land cover under pass issued by village council in the present case is not against the public policy of India, since the passes in questions meant for agricultural purposes were
Okay, you are in item 10.
Yes, Your Lordship.
Okay.
Yes.
Okay, I was thinking this item 11. Okay.
Yes.
Yes.
Were issued by the incompetent authority. Moreover, it is opined that the impugned arbitral order dated 14/8/2023 is not perverse due to merely the fact that the report submitted by the joint spot verification team in respect of the land belonging to the petitioner number 1 was not accepted by the learned sole arbitrator. It is opined that the impugned order is not against natural justice, not contrary to the substantive law and against the public policy of India, Your Lordship. That is the findings of the civil court. And also in
Let us see what is the findings of the arbitrator.
Your Lordship, it is the same.
Where is it?
Arbitral award on page 30, Your Lordship.
30.
Yes, Your Lordship.
Yes.
On para 7, Your Lordship.
Yes.
Regarding payment if market value of land, all the petitioners are
Para 7.
Yes, Your Lordship.
Page
38.
Yes.
Regarding payment of market value of land, all the petitioners are holding VC Garden Pass. Curtailing of powers of the VC Pass was done and divided so and so by declaring Bill Cotlier as notified town. Along these declarations, the power of the village council to allot land was also withdrawn. Thus, village councils in these sub-town areas ceased to have legitimate authority to make new allotment of land. Traditionally, rural lands in Mizoram have been maintained like a community land wherein village councils could allot land for temporary period of June cultivation, kitchen, garden, etc. on an annual basis with no inbuilt enduring right. Likewise, temporary utilization of community land permitted by village council in sub-town areas could not amount to acquisition of legitimate authority for them to allot land, since this is the legal position of the state government. Even land acquisition proceedings cannot override or alter the land law. Therefore, land allotment by the village councils in notified town and sub-town areas without authority has no legs to stand, and in the result, land assessment is not to be made, being land held without sanction of appropriate authority. In other words, so-and-so genuine land allotment cases in notified town areas of Bill Code here would continue to avail appropriate benefits in respect of other village land allotment by the village councils under 1953 Act and 1956 Act prior to 2013 would also derive normal benefits as well. However, cases of allotment by village councils post so-and-so would lack legal sanction. Kala is understood to know his legal position. In addition, allotment done by the village council has to be further corroborated by the temporariness village council's court record minute book clearly confirming such land allotment. Few cases of claim of compensation would inevitably be ignored or rejected if they fail to fulfill the conditions mentioned herein. In such cases, the arbitral order would not interfere with the decision of Kala. In the course of hearing, the learned ARs have drawn attention to the Gauhati High Court judgment order in LA Appeal 3 of 2019 in case of Liendinga and others versus so-and-so. The ARs relied on the conclusion of the judgment to counter the conclusion of Kala is not assessing land value of land held under VC Pass. It is pertinent to mention that the judgment came to the conclusion that once the title and rights over land allotted by VC is freely transferable and heritable, it is to be regarded as valid pass or pass. It is also relevant to state the fact that several land allotments done by village councils have been regularized by issuing pata or land settlement with approval of the government of Mizoram. In fact, only such cases are legally transferable and inheritable. The test applied by the Honorable High Court is on a truncated position, and that the conclusion drawn therein would not meet the test whether the said landholder can legitimately be held to be a landowner under the Land Acquisition Act 2013 so as to qualify for receiving market value for the land acquired unless the government Mizoram gave approval for regularization. In other words, the cited High Court case is clearly disguised. Therefore, the view held by Kala as regards the status of VC Pass is upheld, Your Lordship. In this
so where is the Kala's decision?
Your Lordship, the Kala decision. Your Lordship, the Kala decision was only considered from the written objection.
Where is it? No. So Kala did not give you compensation for the land.
Yes, Your Lordship.
It gave you compensation for the crops.
Yes, Your Lordship. Crops and trees.
And in the award made under 3G.
Yes, Your Lordship.
When was the award made?
Award made on? Award made on 10/1/2023, Your Lordship.
This is the same arbitrator who has in all the cases I think they've been given only crops and trees, not for the land. Correct?
That depends upon the kind of holding.
No. For the VC pass
yes,
for agricultural land,
yes.
I think no one has got for the land.
Definitely, yes, my lord.
Even from the arbitrator, they have not got.
Yes, my lord. Depend upon case to case, my lord.
So yes, and their VC pass, the earlier case was agricultural land.
Yes, Your Lordship.
Before your Lordship, there are two different cases. One is with respect to the VC pass.
No, the one I did just now. The one I am sending back.
Yes, Your Lordship, garden pass.
That was with respect to 5 buildings.
That was not with enhancement.
hearing, yes.
No enhancement. Okay, done. Okay. Anyway, so Kala decision is where? Page?
Your Lordship, page 130.
113.
Yes, Your Lordship.
Yes.
On page.
But where is the award? There is no award.
No, Your Lordship.
This is only an assessment done.
Yes, Your Lordship.
And your land has been taken away, is it?
Yes, Your Lordship.
Now this is Lalnun, Tluanga.
And 3 others, Your
And
Lordship.
3 others. Ram Ropu is one of the petitioners.
Yes, Your Lordship. And Your Lordship, page 61. There is a.
No. Where are you? Where is all the petitioners? Petitioners are in which pages? Appellants, I mean.
Page 2.
You see, come to 113, page 113. This is the compensation for crops for Ram Ropui.
Yes, Your Lordship. That is the petitioner.
But there is the appellant, you mean? But there are 4 appellants.
Yes, Your Lordship.
So who are the others? Where are the others?
Your Lordship, on page 69, there is also a VC pass. That is the appellant number 1. Page 69.
So, anyways, these are all garden passes, correct?
Yes, Your Lordship.
So, you are challenging. So, what is wrong? What is wrong with the decision of Kala not to give you compensation?
Your Lordship, may I take Your Lordship to page 7 of the appeal memo?
Yes.
Your Lordship, denial of market value of land in violation of Section 3G7 National Highway Act and Sections 26 and 28.
Page?
Page
Para?
7.
Page 7, yes. Yes.
For that the learned arbitrator and the learned civil court committed patent illegality under Section 34 2A of the Arbitration and Conciliation Act 1996 by denying market value of land to the humble appellants in direct contravention of mandatory statutory provisions. Section 3G7A of the National Highway Act 1956 mandates that the competent authority or the arbitrator, while determining the amount under Section 1 or subsection 5, as the case may be, shall take into consideration the market value of land on the date of publication of the notification under Section 3A. This provision is mandatory and applies to all acquired land without
Mr.
any...
Counsel, this is not the issue. The issue is only a landowner
Yes.
can be given compensation.
Yes, Your Lordship.
Correct?
Yes.
If you are not a landowner, you cannot be given compensation for land.
Your Lordship, the
No, please answer the question. Have you understood what I am saying?
Yes, Your Lordship.
If supposing I want to buy, look at me, Mr. Counsel, don't look there, look at me, I'm talking to you. There is a basic decorum and decency that you can show to the court by looking at the judge when he is talking to you. The issue is, supposing I want to buy land, your land, then you will sell it to me, correct? Yes. Now can I buy your land from him? from another person without your permission. I cannot.
Yes, Your Lordship.
Now, the land that you have is not your land because the VC pass that has been given to you is an invalid, void pass. So, where is your case?
Your Lordship, may I reply in that regard?
Yes, yes.
On page 120 and 121, Your Lordship.
121.
Yes, Your Lordship. There is the three appellants was approval for periodic pata.
Approval might be there, but then that does not relate to, you see, unless you get the periodic pata, you don't have any right. This is 14 January 22.
Yes, Your Lordship.
And when was the award made?
On 10/1/2023.
10/1/23.
Yes, Your Lordship.
Award under 3G on 10/1/23.
Yes, Your Lordship.
And when was the assessment made?
Assessment, Your Lordship.
When was the freezing order issued? When was the the notification under 3A issued?
21/5/2021, Your Lordship.
21/5/2021.
Yes, Your Lordship.
And your approval for the thing?
Your Lordship, on 10/1/2023.
Page?
When the award was published.
Page. No, approval for conversion into periodic pata?
Your Lordship, 14 January 2022.
So after the section 3A notification.
Yes, Your Lordship.
Where is that section 3A notification?
On page 61. 21/5/2022.
Page?
61, Your Lordship.
Page 61.
Yes, Your Lordship.
Where do we get the date?
Your Lordship, the date was not mentioning.
How did you say it is at on 21/5/2021?
I know from the list of dates in C, page C.
Page
C.
C.
From the list of dates.
List of dates, page C? Which page is that?
Page C, Your Lordship.
C.
After synopsis.
Okay. Okay, right. Heard. Mr.
Lalthang Moya.
Huh?
Lalthang Moya.
Lalthang Moya, learned counsel for the appellants, who submits that the impugned arbitration award, the impugned judgment and order dated 27/1/26 passed in arbitration petition number 2 of 2023 by the Court of the Additional District and Session Judge, Aizawl District, Kolasib, Aizawl Judicial District, Kolasib, dismissing the arbitration petition number 2 of 2023, which has put to challenge the arbitral award dated 14/8/23, dismissing the claim of the petitioners for payment of compensation for the value of their lands, should be set aside. Next paragraph. The learned counsel for the appellant submits that the four appellants are owners of lands covered by, where is the passes numbers, where is that?
On page 69. VC pass.
Are owners of lands covered by village council passes issued for the purpose of agricultural purposes. Full stop. For the purpose of construction of a 4-lane road along the National Highway 306, NH 306, bracket Vairengte via Sairang. Vairengte to? What Vairengte Sairang? How could it be? To Vairengte to Sairang?
Yes, Your Lordship.
Then you said Vairengte via Sairang. You should say Vairengte to Sairang. Vairengte to Sairang, comma. The respondents issued a notification under Section 3A of the National Highways Act, 1956, and thereafter issued an award under Section 3G of the National Highways Act, 1969, 1956, hereinafter referred to as the Act. As the NH Act, Next para. The appellants, sorry, not the petitioner, the appellants were given compensation for their crops and trees on the lands covered by the VC passes issued for agricultural purposes. However, compensation for the land was not given to the appellants. Next para. As the being aggrieved by not being given compensation for the land, the appellants submitted an application for referring the matter to an arbitrator under section 3G bracket 5 of the NH Act. Full stop. The learned arbitrator passed an award dated 14/8/2023. What have I said? What is AR? AR means acquiring agency, is it? No. AR means what? Authorized representative. Okay. What did it hold, the arbitrator? What did it hold? What have I said? By holding that, it upheld the view of Kala, Kala, respondent number. Kala is not a party here. Kala is not a respondent number 1. Wherein it had been held that, wherein it had been, who had held that? In terms of Government of Mizoram notification number LRR-A-1/88/PT-1, declaring Bilkotlir as a notified town, comma, the powers of the village council to allot land had been withdrawn. Full stop. Full stop. On the other hand, the village council passes issued to the appellants were issued when? Were issued on? We were issued after 2017.
Yes, Your Lordship.
Were
Some.
issued. Huh?
Some of the petitioners were issued after.
Give me your village council passes. Just write down the numbers and the date.
On page 69, Your Lordship.
69 is only one.
Yes, and
So
there
there are
is
four of
also
them.
page 78. 78 and 83 and 91.
Which were issued on? Which were issued in the year 2016, 2017, 2018, full stop. The VC pass of the appellant number 2 had been issued on 22 to 2003 to one Lalchan Kima and had been transferred to the present appellant number 2 on, where is this? On
Receipt, it was on page 79. There will be a translation.
No, your translation is not up to date. As per this, when was it transferred? This initially it was not in your name. Here it says here 78 transferred to Lalming Chuang, son of so on 19 and 2020. What is this? Where is the original?
Lordship, this is original submitted to the Kala.
Transferred subsequently, it was transferred sometime on an illegible date. Full stop. The learned arbitrator also stated that traditionally rural lands in Mizoram could be maintained like a community land, wherein village councils could allot land for temporary period of jhum cultivation, kitchen garden, etc., on annual basis with no inbuilt enduring right. Full stop. There is a Zoom regulation in Mizoram where you can give for 1 or 2 years only. You just give me that land laws of Mizoram, that yellow thing. Full stop. The learned arbitrator further stated that has also relied upon a Gauhati High Court judgment what is that? LA appeal. Is there any LA appeal? Computer. LA appeal number 3 of 2019. LA appeal number 3 of 2019. LA appeal number 3 of 2019. Held that also held that in respect of other villages, land allotment by village councils under the 1953 Act and the 1956 Act prior to repeal in 2013 would also derive benefits as well. As such, the learned tribunal held that the appellants were not entitled to compensation for land value. Full stop. Being aggrieved by the same, the appellants put to challenge the arbitral award before the additional district and session judge, Aizawl Judicial District, Kolasip, wide arbitration petition number 2 of 2023. The learned civil court It has sent it back to the arbitrator.
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
So what is wrong with this?
I read in para 21 and 22. This is also the court findings.
Where was it? The learned? Wide judgment and order dated 27/1/26. remanded the matter back to the learned arbitrator to rehear the matter and consider whether the appellants were entitled to land compensation. Compensation for the land, correct?
No, Your Lordship, it was already decided by the civil court.
I know, but then it has been remanded for what purpose?
Remanded for, Your Lordship, on para 24, Your Lordship, to reconsider as per law the...
To reconsider what?
Yes. As per law, Your Lordship.
To consider what?
As per law, it is not mentioned about...
So now what to do? To reconsider, okay. How it has said this? Anyway, so... What have I said? Remanded the matter back to the learned arbitrator to reconsider the matter afresh. Full stop. However, in para 21 of the said impugned judgment and order, the learned arbitrator has held that, in his considered view, non-payment of market value of land in respect of lands covered under pass issued by village council in the present case was not against the public policy of India, since the passes in question were meant for agricultural purposes. Passes meant for agricultural purposes were issued by an incompetent authority. It also held that the impugned arbitral order dated 14/8/2023 was not perverse. You see, you have got to learn how to. Have you got a senior?
Yes, Your Lordship.
Who's the senior?
Mr. Lasoirama.
Where is he?
He's in hospital, Your Lordship, for dialysis.
That's why you're doing. Okay.
Yes, Your
Anyway, what have I said? I don't understand what just put there full stop. Next. On considering the impugned judgment and order, this court fails to understand as to what should be decided by the learned arbitrator, when the learned civil court has not found anything illegal or against the public policy of India in relation to the arbitral award that has been put under challenge. Before the learned civil court. I don't know what is the law is clear, but the problem is, what has the civil court done? It has said that in his considered opinion he doesn't find anything wrong, and he sent it back to the arbitrator. What will the arbitrator decide? Full stop. On considering the above, para 21. No, first up. Further, the learned court has held that the learned civil court has held that it finds no reason to interfere with the arbitral award or modify the impugned arbitral award. Full stop. Para 21, 22, 24, 25, 26 of the impugned judgment and order dated 27/1/26 passed in arbitration petition number 2 of 2023 is reproduced herein below as follows. Next para. As can be seen from the above, when the learned civil court has come to a finding that it does not find any reason to interfere with the arbitral award, there was no justification for directing the matter to be sent back to the learned arbitrator to decide the matter. It basically amounts to dismissal of the arbitral, the application under section 34 of the Arbitration Act. Correct?
Yes, sir. Yes, sir.
Now you have come before me to do what? To see, to challenge these observations.
Yes, sir. Yes, sir.
So,
To challenge,
next para.
sir.
Next para. The the basic challenge to the impugned judgment and order is on the ground that the appellants are entitled to be given compensation for the land as they have been issued village council passes. Further, the village council passes of who were PP, the ones who were to be PP? Village council
2, 3 and 4.
Of appellants number 2, 3 and 4
Yes, sir. Yes, sir.
had been approved for being converted into periodic patas by the government vide letter dated 14/1/2022 issued by where is you don't even have the proper thing, issued by where, issued by whom? These documents are all there's nothing, no signature. Come to page 120.
Yes, sir.
No signature, nothing. By the government, full stop. That's all. 14/1/2022. Full stop. I have heard the learned counsel. No, the full stop. As can be seen from the. No, full stop. I've got lost with your submissions and everything. I'm totally lost now. That's right. This court is of the view that the approval given by the government for converting the VC garden passes of the appellants number 2, 3 and 4 on 14/1/22 cannot have much relevance in the present case, in as much as the notification, give me the NH Act, in as much as the notification under section 3A of the NH Act had been issued on 21/5/2021, declaring its intention to acquire the land of the appellants. Full stop. That is beyond, that is before, that is prior to the approval given by the government for converting the village council passes into periodic patas. No, for converting, no, for regularizing and converting. Earlier also used regularizing and converting. Full stop. Further, basically, okay, just say the case is dismissed, appeal is dismissed. Acha, I heard Mr. Jonathan.
They are in Tuanga.
Should I say heard you? Should I say heard you also? No.
I have not even filed my.
Oh, you're not there. Dismissed. You have got a lot to learn, Mr. Counsel. Submission wise, everything. Anyway.
Item 11.
This is which matter?
It's the first time listed.
What is this matter? Yes.
It's similar to the other matter for revising the price decided by Kala on the same grounds. Enhancement on the same grounds.
No reasons given.
Sorry,
no reasons.
No reason given, my lord.
That's
yes.
all.
Yes.
Okay, heard Mr. Karthik Jain, learned counsel for the appellant who submits that the learned arbitrator has enhanced the compensation to be given to the respondents, private respondents, without giving any reasons or the basis for making the enhancements. Issue notice returnable in 4 weeks.
So if I may, I'll be accepting notice on behalf of Kala.
Kala?
Yes, Your Lordship.
You are just standing, how can you be standing counsel for Kala? It's not an institution. How can you, it's not an institution. Kala, it's a different, which district?
Kolasip.
Oh, for Kolasip.
Yes, Your Lordship.
You're standing counsel for Kala, Kolasip?
Yes, Your Lordship.
Okay, issue notice returnable in 4 weeks. Mr. Jonathan
Lalrintlong.
Lalrintlong accepts notice on behalf of respondent number. Kala is what number? Off the
Malad 12.
live streaming off.
12, Your Lordship.
Huh?
12.
12. Minister? 8 Zorin Sanga.
All the private respondents.
Accept notice on behalf of response number 1 to 11.
Yes.
1 to 11. When do you want the matter?
Your Lordship, next